All right, good afternoon, everyone. Welcome back to the Judicial Proceedings Committee. Today's Wednesday, March 26, 2025. We have 16 bills on the docket, and I see Delegate Foley is here with House Bill. She was just here a second ago. Is she still here? Oh, there you are. There you are. House Bill 74. Welcome.
Thank you, Mr. Chair. Up here or down here? Thank you. It's been a while since I've been in this committee to testify. And yes, we are done on the House floor with the budget. So, good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed members of the Judicial Proceedings Committee. For the record, I'm Delegate Linda Foley, and I'm presenting HB 74, legal advertisement or legal notice, publication in newspaper of general circulation, digital newspapers. Thank you for the opportunity for me to present this bill. As a former journalist and former president of the union representing news workers, I believe it's crucial that we update our state laws to keep pace with the changing media landscape. The rise of digital publications has dramatically changed how the public accesses information, including legal notices and advertisements. In addition, the finances and scope of local media in Maryland has changed drastically since the legal notice statute was first enacted. That's an understatement. For some context, the Philip Merrill School of Journalism at the University of Maryland recently conducted a comprehensive study that provides a snapshot of the current local media landscape in Maryland. We all know how critically local-based, journalistically sourced news outlets are to the functioning of our communities and democratic governments that run them. The study was attached to my written testimony if you're interested. The Merrill study found that 176 local media outlets in Maryland, there are 176 local media outlets in Maryland, 156 of which are focused on news and journalistically supplied content. 78 of them are print-based, quote-unquote, newspapers that also publish websites or PDFs of their publication. 53 are digital-only publications. The study also looked at the geographic landscape of Maryland's local media. There's one county, Caroline County, with no news outlets at all, and 8 counties with 3 or fewer outlets. While the number of so-called legacy medias, newspapers, television stations, et cetera, is shrinking, the number of media outlets in Maryland has grown since 2020, all with the growth coming from startup media companies. It's important that local media outlets be supported. It's also important that there be regular independent notice of local government functions available to members of the community. Local independent news outlets are the best vehicles to fulfill that mission. Solely posting required legal notices on government websites is contrary to basic transparency and the constitutional role of a free press. That's why current law has clear requirements for the publication in independent media of local notices and advertisements by counties and municipalities across Maryland. This bill would allow the notices to be published in both print and digital formats, providing access to the widest possible audiences, and at the same time providing some cost savings for some municipalities and counties. Importantly, HB 74 also mandates that any digital publication running these legal notices must have an archive accessible to the public and employ at least one employee, nobody in their basement doing a blog, okay? Focused on reporting local news and information. This will help guarantee that local legal notices remain readily available and are accompanied by context and analysis that the citizens need to stay informed. It also guarantees that any digital publication containing legal notices is a legitimate ongoing concern. In an era where many newspapers have shuttered or reduced coverage, it is essential that we adapt our laws to conform to the new media reality. This bill strikes the right balance, leveraging digital platforms while upholding key standards of transparency and journalistic integrity. A similar bill covering just Dorchester County was passed last year. It's also important to note that HB 74 has passed the House unanimously. For all these reasons, I urge a favorable report on HB 74 so we can help bring Maryland's public notice requirements into the 21st century. I thank you very much for your attention. I'd be happy to answer any questions, Mr. Chair.
Thank you, Mr. Chair. Good afternoon, Delegate Foley. Thanks for bringing the bill. Just to clarify, when the section on Dorchester County is deleted, it is because the bill is applying what they did statewide, so that is superfluous and unnecessary. Is that correct?
Yes, Senator, that's correct.
Great, thank you.
Thank you. Thank you for bringing the bill, Delegate. You had mentioned about 156 digital outlets. So my question is, how do we make sure that the public is pointed to the right outlet? Seems to be 156 is voluminous, and I'm not exactly sure that that is as friendly as letting it sit in print media. So, I mean, how do we know where, are we going to the Banner? Are we going to the Sun? Are we going to Daily Record? Are we, how does the public know where to look for this notice if it's not in a standard print model?
Right. The public, in terms of the public, I think it depends on, what the public is reading, and that's hard to gauge in this day and age. I'll grant you that. And not all 156 of those publications, I think, would qualify under our law and this bill, which includes some of the current law, for criteria of what qualifies as a local newspaper. We're expanding that definition in this law, right, to include digital, but a local newspaper, it's very specific in the law what that means, and there are very specific criteria. So I'm not sure if all of the 156, in fact, I know that all the 156 would not fall under this. And so I think it's just a question of, we don't know what people are reading, but we hope that they're accessing some sort of local news media outlet that has what the bill says is general circulation in the community. That's the only way I can answer that.
Okay. It just seems to me if we pass this bill, we're actually making it more confusing for the public to get public notices of what their local governments are doing.
If I may, Senator, I'm not sure I agree with that. I mean, right now, it's still, if people don't subscribe to a newspaper now, they don't get it.
Well, and my counter to that is, I'll say District 1. You've got the Garrett Republican, you got the Cumberland Times News, and you got the Herald Mail. That's all three of those counties, Garrett, Allegheny, and Washington County. If somebody chooses to not go into those, that's their own choice.
Correct.
But the standard is that public notices on local public notices are there. If this bill passes, you're telling me out of the 156, we're not exactly sure how many actually fit the standard. And where am I going to tell the people of Garrett, Allegheny, and Washington County to go get their public notice if we don't know where they're getting their news in other digital forms?
I don't think that this would, first of all, they have, under the bill, they have to go to the media that has a print outlet first. So it may have a print outlet and a digital outlet, but if that's not available, which is not the case in the counties that you suggested, because you just named 3 local newspapers that are there, then those local newspapers would continue to be the repository of these notices. But they would also go online. They could also go online.
Okay, well,
with those newspapers is what I'm saying.
I see the benefit of it going online. My problem is making sure that the public understands where they need to go for these sources. And I'm not exactly sure how that does this, but we can talk offline.
Sure. I would just say that I think in the counties you cited, nothing is going to change. It sounds like nothing is going to change because there are local newspapers there.
Okay.
Yeah.
Cool. Thank you so much.
Thank you.
Good afternoon. Last year, I remember we had passed legislation that ultimately ended up being vetoed by the governor, where we were trying to move to digital and away from print. I'm curious. I note that within here it says print and digital. Do you? And again, he vetoed the legislation, but it made some sense that we were trying to move away and save costs. Would you mind speaking to that and why, in relation to this legislation?
To the legislation that was vetoed, Senator? Is that what you're asking?
Right, in relation to this. So
yes. So thank you for that question. The legislation that was vetoed by the governor was with respect to estate sales. It was not, there are other legal public notices that are not estate sales that this bill addresses. But I believe that the way current law is, that estate sale notices would fall under this now. If that bill had not been vetoed, they would not have. So they would be an exception to what the law is now. So this bill does not seek to define what the content is that's required in these notices. For example, whether it's estate sales or notice of a charter amendment in a community. But what it does do is say where these, it sort of guides where these notices can be placed with some parameters, if that helps.
Yes, and I'm assuming, because many digital imprint, you have to pay for many of these things. Would this stuff be available for free?
No, this did, well, I can't speak to that, depends on the publication, but generally, this is available to subscribers of the publication, either in print or online. Now, some of these websites may be free, but they do have to have an employee if it's a digital-only publication, which means they have to raise money somehow. So they may not have subscribers necessarily. They could be advertising supported, but they would have to be supported somehow.
The notices, the legal notices, would that portion be free?
I'm sorry, I'm having a hard time hearing.
Would that portion be free?
In the case of a digital-only publication, we are requiring that there be a public archive, meaning that at some point the public would be able to access that information without going through a paywall.
Okay, thank you.
If that makes sense.
Yes, ma'am. Thank you.
Thank you.
Senator West. Thank you, Mr. Chair. Interesting bill. It looks to me as if it's going to cost the people who have to put ads in the newspapers more money, because they'll not only have to put them in the newspapers, but also find a digital platform and put them on the digital platform too. Am I right on that?
No, Senator, actually not. What this does is, first of all, every single one of these publications, and this is in the data, every single one of these print publications also has a digital component. So if I buy an ad, for example, one of these ads in the Washington Post, then it automatically goes on the digital website.
Okay, I'm thinking years ago when I was, before I became a full-fledged lawyer, when I was in college, I worked for a lawyer in Baltimore County in Towson. And we had a legal newspaper called the Jeffersonian.
Right.
I'm not sure anybody ever really read the newspaper because there was nothing in it except legal ads. I've always thought that newspaper probably is mired in Neanderthal times, and I wouldn't be surprised if they don't have a digital format. Are you sure that every one of these legal newspapers in the state has a digital format?
Based on the data from the University of Maryland study, I am fairly confident that that's the case.
Okay. So it wouldn't cost any more. We'd just be putting the ad on the newspaper and on their digital platform.
In that case, yes. And then the difference is that if there isn't a newspaper of general circulation as defined in the definition, then they could put it just on a digital media site. I mean, I will say something else, Senator. I think that part of the issue here is that these local media, and I kind of rushed through testimony, but if you look at the Merrill study, local media is migrating to digital-only formats. I mean, and this is a trend that's going on all around the country. In Cleveland, for example, you can't really get the Cleveland Plain Dealer home delivered every day, maybe 2 or 3 days a week. The rest of the time it's online. And in New Orleans, the New Orleans Times-Picayune is the same, that you can't get it delivered. You can't buy it in print, that it's only online. That's happening in a lot of these jurisdictions, and I suspect, and I know it's also happening in some counties in Maryland, including my own.
Yes, my observation is that these local print newspapers are going out of business very rapidly. There are only a fraction of them in existence today compared to 25 years ago.
Yes, that's accurate. Yes.
When I first read the bill, my concern was that this bill was going to contribute to that, accelerate that process of driving small newspapers out of business. But now that I've read it more carefully, we're not saying the ads don't have to be in those newspapers.
Correct.
They just should be in the newspapers and on the
Correct. And then-
associated digital platforms,
Yes,
which makes sense.
Exactly. And if that's not available, that meet the criteria, because the criteria, they're in the list. If that's not available in a certain place, then it can be put on a digital-only platform.
Like in Caroline County, where there is no
Correct.
longer a local newspaper.
Correct.
Gotcha. Okay, thank you.
Thank you for the second bite. Of those newspapers in print, who then have a digital offering, do you know by chance how many don't put that on there automatically? Most digital that I see will have an actual digital
I'm
of
looking to my friend from the Press Association. She says that they all do it digitally as well, that there are none that don't put it on their digital platform as well.
Correct.
Am I right about that? Okay.
So
Yeah.
that part of, okay. All right, thank you.
Uh-huh.
All right, further questions from the committee? All right, seeing none, thank you very much, Delegate. Thank you.
Thank you.
Thanks a lot. All right, with that, that'll conclude the hearing for House Bill 74. We'll now move on to House Bill 302 with the Majority Leader Moon.
Good afternoon, Senators. House Bill 302 is a by-request bill that came from Montgomery County government, and it is in relation to the commissioner, the process by which a citizen can go to a commissioner and have criminal charges drawn up on someone based on their word. We actually had a whole nother bill that was a wide-ranging bill trying to reform this topic, but this, in contrast, is a very narrow bill. So if you've probably heard about this topic, someone can go before a commissioner, write up a statement of charges, and have criminal charges brought on someone on their word. We have an exception to this process for certain people who are facing these criminal charges in the course of their work. And that includes teachers, police officers. You can't just go bring criminal charges against one of these people in the course of their work. Those charges get sent over immediately to the state's attorney for review, and a decision will be made as to whether a warrant is issued, but they go immediately for state's attorney's review. And the obvious reason is you don't want a teacher or a police officer to have some sort of fraudulent retaliation from people they're interacting with at work. So again, there's an exception to this process. And so the bill from Montgomery County would add adult protective service workers and child protective service workers to this list of professionals who the state's attorney will review before a criminal charge is filed against them while they're at work. And so the reason for it is these are folks that make adverse decisions against members of the community, and so they can therefore face retaliation while doing it. That's the bill in a nutshell. I think a lot of folks will say, well, why this profession? What about X, Y, or Z profession? And I actually think it is the view of many of us on the Judiciary Committee that we were trying to do greater reforms to the commissioner charging process, and I wouldn't be surprised if in future years we were open to adding additional professions into this state's attorney review process. Happy to answer any questions.
Thank you, Mr. Chair. Just briefly, you keep referring to this as Montgomery County, but I can't find anything in the bill that suggests that it's limited to Montgomery
It's
County.
not limited to Montgomery County. It was born out of a request from Montgomery County because they had actually had a child protective service worker who was brought up, someone came in, they didn't like the decision that was made against them with respect to their children, and suddenly this person at work is facing criminal charges. And part of the concern was they were ineligible for a public defender representation, and because of the nature of the allegation, the government felt it was sort of outside of the scope where they felt compelled to put up a legal defense for this particular person. But again, it was in their course of work and totally trumped up charge.
Let me say, I'm not opposed to this bill, but I do think we need to take a more holistic look at this whole idea of citizens going and pressing charges. And so, yeah, we can add these 2 extra categories to the list, but we need to take a bigger look at the whole process.
I don't disagree with you, and we actually, in the criminal law subcommittee in the House, we actually started advancing a much larger bill that came from delegate, and I can't remember, I think it might have been McCrae had it in the Senate, but there's a larger bill. It still might move. We were still working on it in the criminal law subcommittee.
Okay. Thank you.
We had a really robust discussion about this. I forget who had that bill, but there's obviously a balance between public safety, and then also we had a really compelling testimony. An individual was, arrested, false charges.
One of our
detained for
constituents.
several days, lost, apartments, jobs, all those things. So definitely a very complicated issue worthy of more discussion, but like this bill. Further questions from the committee? All right. Thank you very much.
Very much.
Thank you. All right. That'll conclude the hearing for House Bill 302. We'll now move on to House Bill 295 with Delegate Holmes.
Good afternoon, ladies and gentlemen of JPR. It's great to see you all here again. I am here today to talk to you about House Bill 295. And House Bill 295 is a bill that is referencing the governing bodies of annual meetings. And the purpose of this bill, ladies and gentlemen, I want to start with that. We have all had this discussion previously in that if you live in a common ownership community, there's really no place where you can gain access into what's going on with your community until you're in it. Here, we are providing the opportunity for a board of directors to be appointed when the developer is still in control at 25% when the unit owners or homeowners take over. And the whole purpose of this, because currently what happens is that in a condominium, when you reach 50%, the declarant steps back, hands you the books, and you're on your own. And the termination stops and starts just like that. There's no intellectual history that takes place from the time frame that the condominium unit owners take over at all. I was very fortunate, and when my community was being built, the developer allowed me to be on the board of directors while they were in a transition period. That allowed us to have that historical content from when we finally took over from the declarant to when the board of directors took over. Initially, the Building Industry Association had some objections to this because initially the bill had information in there about bonding requirements. That's all been removed and taken out of the bill. So now the bill is simply referencing the fact that when 25% of the owners are participants in that community, the developer or the declarant will appoint one member, a unit owner, and they would participate until the board of directors is until they reach a 50% level and the board of directors is created. That's all this bill does. We need to have something where the persons can get that intellectual history before they're handed the books and the declarant just moves away. That's what we're trying to do. And I'll take any questions.
Mr. Chair, so I've got, I guess, an organizational question. So in a condo, when half the units have been sold, then normally the board of directors gets formed because up until that point, the developer of the condo owns most of the units. And so he sells his first unit, and let's assume it's a 100-unit condo. The developer now owns 99 units, and he sold one. Now he sells a second. He owns 98 units, and 2 are held by other people. So the developer has the power to control the board up until the time half the units are sold, and then the board can get going, an independent board can get going, and the developer, as you say, steps into the background, and the board basically controls things. And the board has certain responsibilities under the condo documents and certain rights. So if under your bill, the developer has to establish the board at the 25% level and appoint at least one person to be on the board. You've got a board which only controls 25% of the units. The developer still controls 75%, but under its condo documents, doesn't the board have responsibilities? And how can the board have responsibilities that it can discharge effectively if it only represents 25% of the units in the condo? So that's my question.
I understand totally. First off, a board in the term of board of directors is not established until there are 50% ownership, okay? This 25% threshold is when the declarant appoints one person to be in consultation with the declarant. But the official officers of the board of directors are not established until a 50% threshold is hit.
Okay, now I'm looking at your bill on page 6. It says if no board of directors has been appointed, yada, yada, and then once 25%, then, quote, the developer shall establish a board of directors for the council of the unit owners and shall appoint at least one member to that board.
Yes.
So the board is being established when the independent owners only own 25% of the units.
That's correct. That's correct. You are correct. The board is established at 25%, but the board of directors do not take over until 50%.
Okay, does the bill say that?
At 50% is when the unit owners or the members who have purchased it take over from the declarant. But until that point, between 25 and 50% is when one member is on the board with the declarant so they can see how the condo, et cetera, is being run. And then at the 50% level, then the declarant hands over all the books and they then elect officers. They can't elect, the unit owners or the board members cannot elect officers until that 50% point.
Okay, so you're drawing a distinction between establishing a board and having a board which actually has powers.
That is correct. That is correct.
This board gets established at the 25% level and actually gets power to do stuff at the 50% level.
That is correct.
Okay. Is that made clear? I haven't read the bill really carefully. I'm just looking at it now.
Yeah, it is very clear, and it is also in other parts of the Condo Act,
code.
et cetera.
Okay.
Yes, it's repetitive throughout.
I understand. Thank you.
Questions from the committee? All right, thank you very much. Seeing none, thank you.
Thank you.
All right, with that, that'll conclude the hearing for House Bill 295.
That it?
Yeah, you're off the hook. There you go. Appreciate it. Thanks. Thank you, Delegate. So we have House Bill 339, Delegate Lehman.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed members of the Judicial Proceedings Committee. For the record, I am Delegate Mary Lehman, and I'm here to request your favorable report on House Bill 339, Real Property, Residential Rental Apartments Air Conditioning Requirements. House Bill 339 states that rental units in newly constructed apartment buildings with 4 or more units must include air conditioning capable of cooling the unit to no greater than 80 degrees Fahrenheit for the state's existing building stock. It also states that air conditioning must be included once a rental unit undergoes a renovation that includes the replacement or substantial upgrade of electrical systems or heating systems. This includes replacing a gas boiler, a water heater, or other substantial electrical work. Notably, the bill does not specify what type of air conditioning must be installed. That is left up to property owners. And any combination is acceptable of heat pumps, central air, window units, or other types of cooling as long as the unit can be cooled to that 80-degree threshold. The air conditioning requirement applies between June 1 and September 30th, which are typically the hottest months of the year on average. If this idea sounds familiar to some of you, that's because it mirrors existing law in both Montgomery and Prince George's counties. Both of those counties have air conditioning mandates in apartment buildings from June through September and use that 80-degree threshold temperature. The version of the bill before you today is the result of hard work and compromise with groups including the Maryland Multifamily Housing Association and Apartment and Office Building Association of Metropolitan Washington. They opposed this legislation last year and earlier in this session, but are now neutral on the version before you today. And I'm going to say that one more time. Landlord groups that previously opposed this legislation are now neutral. Mr. Chair and committee members, I want to say that this is really more than a housing or a renter's rights bill. Those things are certainly important. However, I'm asking you to think of this bill in the context of public health, disaster mitigation, and community resilience. In 2016, the Maryland Department of Health, along with the University of Maryland School of Public Health, published the Maryland Climate and Health Profile Report based on a decade of Maryland hospitalization data. The evidence indicated that exposure to extreme heat events are increasing the risk of hospitalizations due to heart attack and asthma. The report also found that even with current climate change mitigation efforts, extreme heat events will continue to become more and more common in the foreseeable future. During the process of constructing this bill, I spoke with Dr. Amir Sapkota. He was a contributor to the report, and he said that based on the current trajectory of climate change, communities need to adapt. And he said that HB 339 would increase community resilience and, I quote, prevent many deaths. As an example of what can happen when a heat wave strikes a region that is ill-prepared for such conditions, consider that in the summer of 2021, a deadly heat wave hit the Pacific Northwest. It killed 200 people in total, 69 of whom were from the Multnomah County, Oregon area, and that includes the city of Portland. A study that was undertaken by the county afterward dug further into the data. It found that at most, 3 of the individuals who died had air conditioning units that were on and in working order. In one case, a portable air conditioning unit was found in use, but it just could not keep up with the heat. The report concluded that lack of air conditioning was a key driver in mortality. Last year, this committee, along with my committee, E&T, moved the Tenant Safety Act of 2024. It was landmark legislation aimed at providing much-needed support to tenants living in unsafe housing conditions. However, because Maryland law has no mention of cooling requirements or even an indoor temperature maximum for what can be considered habitable, legal action for unsafe conditions such as I talked about, would face an uphill battle unless cooling is explicitly mentioned in a tenant's lease. This bill, I believe, is a first step toward changing that. I am confident it will save lives, and that is why I am here today urging your favorable report. Thank you, and I will entertain questions.
Chair. Thank you, Delegate, for bringing this in. So in Garrett County, we have 2 seasons, winter and July 4th. So we also have a workforce housing problem. In Garrett County, it's very, very hard to build a multi-unit area because of the costs, land, those type of things. To me, this bill does not help Garrett County with us trying to have workforce. So my question is, the bill coming from Montgomery and Prince George's County, which sounds perfect and it's great, why are we mandating a local government like Garrett County to have this when the need is not there?
Well, thank you for the question, Senator. I think it's fair to say Maryland is getting hotter and hotter with each passing year, and that includes every corner of our state. The bill is prospective, so it is only going to apply to new construction or when existing housing undergoes a substantial renovation. I think it is the right thing to do to keep tenants cool in the hottest weather, and that traditionally has been defined as June 1 to September 30th, as I said. The bill that I brought forth this year was much more scientific and initially and subscribed to what are called ASHRAE standards, but the decision was made in my committee that that was a bit too complex and that the Montgomery and Prince George's standards made more sense. And so I do think it is appropriate legislation for the entire state.
Okay. So because it's hard for us to build multi-units in a county where we don't have a big population and the costs outweigh the return of investment. We've got a local government, Garrett County government, that is actually using its local tax dollars and using every avenue it can, such as the George Edwards Fund, Western Maryland Economic Development, to be able to build these units as cost-effective as possible. There again, I don't understand why Montgomery and Prince George's County are going to dictate to Garrett County where it's not necessary. And therefore, imposing, as the fiscal note says, this bill may impose a mandate on units of local government. It kind of is counterproductive when I'm trying to get the working class the ability to live in Garrett County and work in Garrett County. But when I have state government now telling me that Montgomery and Prince George's County know better, I have a hard time supporting this. And I guess my question is, I'm going to probably work on an amendment for the committee to maybe opt out Garrett County because, like I said, we have 2 seasons, winter and July 4th.
And is July 4th pretty hot, Senator, respectfully?
It doesn't meet
Well, what I would say,
standards of where you say that they are. So literally,
but
we're
what I
gonna
would say,
mandate
in all seriousness is I did not get this idea by looking through existing laws in my own home county of Prince George's or the neighboring county of Montgomery. I also represent Anne Arundel County. Again, I believe it's a good idea for the state, and I came up with the idea based on public health concerns related to the reality of hotter and hotter summers, which we have experienced here in Maryland with climate change. The other thing I would say about the fiscal note and the impact on local government is there would only be an impact for local governments that own or build public housing. And I will tell you, when I talked, but when I spoke last year to someone in Baltimore where there is a lot of government-owned housing, the response I got was, and you know what, Delegate, I'll be really candid, that some of the biggest violators of habitable, healthy housing conditions are, in fact, public housing units. So, you know, there was a suggestion by folks in Baltimore with public housing that it be exempt, and I didn't think that was a wise idea. So that impact, though, on local government is only if Garrett County is building or owns housing. And for private landlords, it is for buildings of 4 units or more.
So, great. I hope you'll consider the amendment because county government is investing in workforce housing. And if we continue to drive the cost up, I'm not going to be able to get the return of investment and be able to keep people in Garrett County to actually work the way it is right now, or live and work. Right now, we have a vast amount of our residents who move to West Virginia or Pennsylvania because housing is much cheaper than it is in Garrett County. I do appreciate the climate change and all this kind of stuff. I appreciate that, but there again, in Annapolis, we have this, well, we do it best, and you need to do it, you do it my way. I'm not saying that that's the premise of what you're saying, but from a county who's trying to do the right thing, to use its tax dollars appropriately, to have the state come in and say, one day out of the year, when it's hot, July 4th, you got to have the air conditioning. And I think if you look at the temperatures, it wouldn't apply in Garrett County. So we can continue.
So briefly, Mr. Chair, if I might, Senator, I'm willing to continue talking to you. I would encourage you and would be interested in the conversation with your local government if they're building workforce housing to ask them, are you in fact planning already to put air conditioning in? And the reason why I raise that issue is when I talk to, you know, the landlord and actually Maryland Realtors and other advocacy groups, their response was everyone is putting air conditioning in new housing. Our bigger concern is your piece that tries to get at renovations. Nobody expressed any concern to me about new housing. They said that's a foregone conclusion that like all new housing, because of our hotter and hotter summers, air conditioning is being put in. So I'd welcome, you know, that continued conversation. As far as an amendment to this bill, I am, you know, turning this bill over to this committee just as I did when I presented it in my committee, and it ended up being significantly amended.
And if I may, Delegate, those would be amenities on how to actually to sell it, not mandated issues coming from the state of Maryland. But thank you very much.
Thank you.
I appreciate the colloquy. Well, at least you got him to admit to climate change. So that's a good foundation. That's a thing. I'm messing with you. I'm messing. All right, good. All right, Senator West.
So now we're going to move to Baltimore City, or maybe from the frying pan into the fire, because Baltimore City does get hot in the summertime. And unfortunately, we don't have any member of this committee that's from Baltimore City. So I was, I guess, the person assigned the duty of taking a delegation from the Housing Authority of Baltimore City and talking with them about this bill. And they explained that while the bill's well-intentioned, the collateral consequences in Baltimore City are likely to be severe. And it's not because of the new housing requirement, it's because of the renovation of existing housing requirement. Mm-hmm. They told me that in Baltimore City, the public housing is 80 years old on average. Mm-hmm. On average. So the average public housing project in Baltimore City was built in the 1960s. That's on average. Mm-hmm. So half of them were built before that. We're talking about a very, very old stock of housing. They also have 6,000 housing units that the Public Housing Authority administers. And they are terribly concerned that because of the language in this bill about whatever substantial upgrades are construed as being, that any substantial attempt on their part to upgrade this old housing stock is going to be made far more expensive by this bill and will deter them from engaging in those upgrades because of the much higher additional expense. They talked about how some of the buildings, there simply is no room to put ductwork in because of how the buildings were constructed. They'd have to put out exterior air conditioning units, but then they have their own problems. If that opening to the outside is a means of ingress and egress, they can't do it there. So they're going to have serious problems. So I hope you'll work with us if we decide to work with your bill and to modify the language about the substantial upgrades in a way which would enable the Baltimore City Public Housing Authority to make necessary upgrades to the housing supply in Baltimore City without having to engage in this very expensive work.
Right. Thank you for pointing that out, Senator. I will say two things. First of all, to go back to how, under what circumstances the air conditioning requirement would kick in for substantial renovations. A renovation that includes the replacement or substantial upgrade specifically of the electrical or heating system. So when you think of an HVAC system, this would be a situation where only the heating part is there. And the thinking is if you're going to replace or substantially upgrade that entire heating system, at the same time, you should put in an air conditioning system. And my second point would be that no one came forward this year from Baltimore City, from the Public Housing Authority, as they did last year, no one at all. And no one as part of those larger groups I mentioned with Baltimore City-specific concerns from MMHA, from the realtors, from AOBA, which primarily represents the Washington suburbs anyway, but no interest or advocacy group that had concerns in the beginning expressed concerns specific to Baltimore City. And by the time ENT amended this bill, again, all of that opposition has gone away. They consider themselves neutral, which is why this is a sponsor-only hearing and you're not hearing from any opponents.
And I fully understand, and I can't explain why they would not have come in the House to make their opinion and would have visited me here in the Senate to let me know days before this hearing that they've got problems with the bill. But it seems to me they do have problems with the bill, and we should try to work through the problems.
Yeah. My point is just that I would have been willing to engage them had they come forward, and they did not.
I'm sure you would have.
Thank you.
All right. Further questions from the committee? All right, Delegate, thank you very much. Thank you.
Thank you.
With that, that'll conclude the hearing for House Bill 339. I see that Delegate Rosenberg is back there. Let's grab Delegate Rosenberg, and then we're going to go to Delegate Warman, and then tackle over to Vogel, and then we're going to Embry because you have an actual hearing. It's not just sponsor only. So, Delegate, welcome.
Mr. Chairman and members of the Judicial Proceedings Committee, House Bill 1367 creates a penalty for falsifying a report a required report regarding the level of lead dust in a facility. There is no current penalty. What the bill would do is create a civil penalty not greater than $50,000. This bill was not opposed by anyone on the House side. I don't think that's why Mr. Enton is here.
I don't know. Looking like the Reaper back there.
One never
All right.
knows.
All right. Further questions from the committee? All right. Seeing none, thank you very much.
Thank you.
Excellent. With that, that'll. He's like the Riddler. We should get him a green jacket with just question marks all over it. All right. We'll now move on. So that'll conclude the hearing for 1367. We'll now move on to 1420. Delegate Warman, welcome.
Thank you, and good afternoon, everybody. Dear Chair Smith, Vice Chair Wall-Stryker, and members of the Judicial Proceedings Committee, including our wonderful new senator from District 16, Senator Sarah Love. My name is Delegate Teresa Warman, and thank you for the opportunity to testify on House Bill 1420. Today marks 1 year since the tragic collapse of the Key Bridge, a disaster that took 6 lives and devastated families across our state. One of the families is that of Miguel Luna, a construction worker and father of 5. He lived and worked in Maryland for nearly 2 decades, but after his death, his fiancée, Carmen Luna, was told she could not serve as a personal representative of his estate. Not because she wasn't qualified, not because she wasn't trusted by his family, but simply because she was not a U.S. citizen. This is not just bureaucratic red tape. This is a moral failure in our laws. HB 1420 seeks to fix that. The amended bill repeals the prohibition that bars non-citizens from being appointed as personal representatives in most cases. It allows grieving families, many of them who are immigrants, who have built their lives here, to move forward with dignity, clarity, and justice. As legislators, we don't always get to have a chance to make direct amends in the wake of a tragedy, but today we do. This bill will ensure that families like Miguel Luna's are not denied their ability to honor their loved ones and carry out their final wishes. Originally, the bill also included a provision directing the Register of Wills to develop alternative methods for individuals without government-issued identification to verify their identity. That portion was removed in the amendments, but the spirit of the idea, making our systems more accessible and more just, remains at the heart of this bill. HB 1420 is not about immigration policy, it's about fairness, and about recognizing the full humanity of the people who live, work, and build lives in Maryland, regardless of their citizenship. I respectfully urge a favorable report, and I will note that it passed the House in a bipartisan manner. Thank you.
Excellent. Thank you very much, Delegate. Questions from the committee? All right. Seeing none, thank you very much.
Thank you.
Thanks. All right. With that, that'll conclude the hearing for House Bill 1420. We'll now move on to Delegate Vogel with House Bill 1257.
Mr. Chair, Mr. Vice Chair, there are so many great members on this committee, so great to see you all. I'm here with House Bill 1257, which is a bill on transparency. We have read, there have been articles, I believe one in the Washington Post recently, on rental junk fees, which landlords are charging that are often surprising tenants. These include a range of different fees, and what this bill intends to do in its final form that passed the House is just require that when you are signing your lease that your landlord provide you with a clear list of what those fees are, what the amounts of those fees are, whether they're optional or mandatory. That way every tenant has the understanding of what they're signing up for and is not surprised when they go to pay their first month rent. With that, I urge a favorable report on House Bill 1257.
You were so fast, I didn't even have a chance to jump up and switch seats. Questions for the sponsor? All right, thank you so much, Delegate. I'm sorry? Oh, Senator West, please go ahead.
Sorry, it sounds like a great bill until I get to the end. And so that's why I was late pushing my button. At the end, so if a landlord fails to disclose a fee for some kind of a fee, it says that the tenant can bring an action against the landlord for violation, I guess, of the failure to disclose the fee, and can recover 3 times the amount of the actual damages. So if the fee was $20, the tenant can recover $60 from the landlord, plus attorney's fees. So the tenant hires a lawyer to recover $60, and then the lawyer gets a couple $1,000s in attorney's fees. Does that make sense? Why are we encouraging tenants to bring suits against landlords for failure to disclose some modest fee?
So thank you for the question, Senator. And you know, I will note, first of all, in the testimony, in the written testimony, there is support from a number of different organizations, including, for example, I believe AOBA came in favorable with amendment. That wasn't necessarily their concern. Their concern was the bill, the enforcement in the original bill, which was penalties. So this was actually amended to address some of those concerns, in addition to a number of different amendments that were put forward on the House side to address other concerns by several landlord stakeholders. So I believe, I can't speak for them, but I believe most folks are content with the final enforcement form, being that it's not a direct penalty.
Okay, thanks.
All right, further questions from the committee? All right, thank you very much, Delegate. Thank you.
Thank you, sir.
All right, with that, that'll conclude the hearing for House Bill 1257. So Delegate Holmes, you had another bill that you were going to present, and then we're going to go to Delegate Tavares. I know you got to get back to committee. I know we're calling you back, and then
Thank you, Mr. Chair.
Buckle, then Embry. There we go. All right. Oh, Delegate Ross is here. Yeah. Yes. Yep.
Oh, thank you, Mr. Chair, and members of the committee. This is HB 360, and this is a Prince George's County bill. Now, the reason why this bill is before you is because back in 2011, we in Prince George's County established a state precedence for the Prince George's County Office of Community Relations. And just to put a pin in that for a minute, you know, all of you know I've been advocating for a number of years to have each jurisdiction throughout the state to have their own CCOC, Commission on Common Ownership Communities. Because as you all know, again, there are very few places that anyone can go to seek assistance for their common ownership community questions, except primarily for Prince George's and Montgomery County. This is relevant to Prince George's County only. In that bill that we passed in 2011, it established a $100 fee for that goes to the Office of Community Relations. This particular bill revises that fee, and it also establishes an alternative dispute resolution process, which is called administrative hearing process. And the reason why we're doing that is because we want to make this particular commission, Office of Community, from OCR, we want to make it very similar to what is being done in the Montgomery County CCOC. And again, I'm trying to model these kinds of things based upon the Montgomery County model, which works very well, by the way. So what this does is it establishes a hearing process. And instead of charging a flat $100 fee, then it's up to the county executive of Prince George's County to decide what the fee is, and that the fee does now go to address this administrative hearing process. And that's all that this bill does. Again, it's Prince George's County only. It doesn't affect anyone else, and hopefully get your favorable support on this bill.
Excellent. Thank you very much. Questions from the committee? All right, seeing none, thank you.
Thank you.
All right. All right, so I know folks got to get back to committee, so we're going to go with Delegate Tavares first, and then Terrassa, both HGO, right? You get to get back to committee. So we will go on with House Bill 1239.
Thank you. Hello, good afternoon, everyone. I have brought with me, in case she's a subject matter expert, Rashida Ogletree, from the Maryland Commission of Civil Rights, in case there's some additional more specific questions. So thank you, Chair Smith and I don't see Waldstreicher, but, and the STEAM committee members. I'm here to request your favorable vote on HB 1239, Fair Housing and Housing Discrimination Regulations, Intent and Discriminatory Effect. This bill passed in a favorably out of the House. Overt discrimination has decreased, but its legacy persists. This bill does not change any existing fair housing protections, but ensures that Maryland upholds and enforces federal fair housing standards at the state level, preventing any potential rollback from the federal level. Disparate impact theory is a critical tool in the fair housing enforcement, allowing claims to be brought against policies that may appear neutral on their face, but result in disproportionate harm to protected groups. This legal standard, upheld in the U.S. Supreme Court case, Texas Department of Housing and Community Affairs versus Inclusive Communities Project in 2015, ensures that discriminatory outcomes can be challenged even when there is no overt intent to discriminate. The U.S. Department of Housing and Urban Development has historically used disparate impact analysis to enforce the Fair Housing Act of 1968, holding landlords, financial institutions, and local governments accountable for policies that lead to housing discrimination. However, federal protections against adversity have come under increasing threat due to Project 2025. And this bill was created as an additional layer of security. This agenda explicitly calls for dismantling HUD's ability to enforce disparate impact claims, weakening fair housing protections across the country. And this bill was specifically requested by the AG's office. Currently, most housing discrimination cases are investigated and adjudicated at the federal level, meaning Marylanders must rely on this administration's commitment to civil rights enforcement. However, the current administration has proven to be unstable. Given the uncertainty surrounding federal protections, it is imperative that Maryland establish its own legal framework to ensure housing justice is protected regardless of federal policy changes. HB 1239 does not introduce any new fair housing laws. It preserves and strengthens the legal protections already in place to ensure Maryland remains aligned with existing federal laws. The bill ensures that constituents remain safe by preserving legal standards at the state level, allowing cases to be processed through state courts rather than relying on federal jurisdiction. This proactive measures strengthens legal protections and provides any additional layer of security to prevent potential harm. In closing, I ask this esteemed Senate committee for your favorable report on HB 1239. Thank you. I'm open for questions.
Thank you, Mr. Chairman, and thank you to the bill sponsor for bringing the bill. I'm looking at page 4, and I feel like there's something I must be missing, so I'm going to ask you to rectify this for me. The first section on page 4 says that you can't do any of the prohibited acts regardless of your intent.
Yes.
And that's subsection A. When it goes to subsection B, it then has the caveat that says a person has not violated this.
Yes.
If the action was without discriminatory intent. So in the top half, it says regardless of your intent. In the bottom half, it says so long as your intent, wasn't to discriminate. How are you reconciling that broad sweep of strict liability regardless of your intent, and then that caveat that says, well, without discriminatory intent.
So thank you for that question. This is why this makes this bill so very, I think, sophisticated and complicated in its nature. The reality is that when we're looking at, for example, in cases of landlords that could say a policy that says, okay, if I'm going to have a policy in place that says, no, if you have if police is called to your unit 3 times, then you're going to be asked to move out. That is going to disproportionately, that may in its face may seem neutral, but it's disproportionately going to affect predominantly domestic violence victims, low-income victims, and so on. So in that case, this may apply. But we are also looking for instances where that doesn't apply, that there may be situations where people are not deliberately trying to create this kind of, that they're protected, meaning that they don't have that in place, and it's just an anomaly that maybe somebody was particularly affected, and therefore this wouldn't apply. And I just want to pass it over to the expert to respond.
Good afternoon. I'm Rashida Ogletree. Good afternoon. I'm Rashida Ogletree George. I'm the Deputy Chief of the Civil Rights Division at the Attorney General's Office. The language that you're pointing out just lays out the 3-part test and the inclusive communities test. And so someone can make an allegation that there was a disparate impact. The person who is being challenged or the housing provider facing a challenge can respond and say that there was legitimate business interest. And then the plaintiff can respond and say, ask whether there was a less discriminatory policy that could have been in place. And so that language simply lays out that 3-part test that's in the case law.
So using the example provided by the bill sponsor, someone repeatedly summons the police officers to their unit, and then the landlord says, I won't renew your lease, or I won't offer a lease because of that. That particular example is not in the protected classes that are already a part of our fair housing statute. So is it the goal of the bill to look at behavior that's outside of the protected classes to see if there's a disparate discriminatory impact?
Just using an example of repeated calls to a housing unit, for example, if a woman has suffered through domestic violence and there are repeated calls to the police, and the landowner, the housing provider, says that any person who lives in the house will face eviction if there's a crime on the property. That may be a disparate impact based on gender, because there's no domestic violence protected category, but absolutely that has a disparate impact on women who live in housing. And so that it's not adding a protected category, but it's certainly adding greater protection for women who may be subject to a neutral policy, but it impacts women differently.
As an attorney, how do you prove that?
There's a process to prove it. The first step is providing statistical evidence that there was a disparate impact. So you would look at how the neutral policy affected a particular protected category. You would look at, for example, with employment, you would look at the applicant pool and the race of the applicant pool. With housing, you would look at the applicant pool as well and make a connection between that policy and how it impacted particular racial groups.
So in the sponsor's scenario, if it were a man who were a survivor of domestic violence and they summoned law enforcement repeatedly and their landlord wanted to deny them housing, if it's not a tie-in to one of the protected classes, are you saying that it wouldn't give that person relief?
Well, gender is protected, and so if there is statistical evidence showing that men are more harmed by this particular policy, that man would have a claim. Does that answer your question?
It doesn't. I'm trying to tease out that particular, because I'm intrigued by that, the particular scenario presented by the sponsor, that if it were something that's not a protected class, but you can link it back to a protected class because it disproportionately impacts that group of folks that are protected in that particular scenario. Let's say the data on who survives domestic violence is disproportionately women. Would a man who survives domestic violence, who was denied housing in a similar way, not be able to use this statute?
It might be more difficult to establish if there aren't statistics supporting it.
Okay. And then what kind of keeps the integrity of the protected class? If the goal of this is to kind of use the protected classes as the starting point, and then to look at anything that happens to see if you can tie it to the protected class, what keeps the integrity of what we've built as a framework?
It doesn't change the protected classes at all. The protected classes remain the same. It just takes a broader look at more subtle forms of discrimination that those protected classes are impacted by. So, for example, because of racial disparities in the criminal justice system, if a housing provider has a policy that says no one with a felony conviction can live in this apartment, that could potentially be a disparate impact based on color and may disproportionately impact Black and brown people because of the racial disparities in the criminal justice system. And so it doesn't change any protected classes. It's still discrimination based on race. It just is, you're able to look at more, a broader range of potential discrimination and more subtle discrimination.
Using that example, if it's a criminal background, the top part of the bill says regardless of intent. And then the second portion of the bill where you get into the test says that you've not violated that part, including the part that's regardless of intent. If the action was without a discriminatory intent, there was a legitimate business interest, and there was no lesser means they could have used. So are we saying that the intent does matter?
I understand the concern that it may sound confusing the way that it's written, and the goal is to make it clear that intent is not the only way that you violate the fair housing laws. Even if there's a disparate impact and no intent, you violate the fair housing laws. That section, the goal of that section is to lay out the legal tests in the inclusive communities case where there is an intent, there's a neutral policy, but it has a disparate impact on particular protected classes. There's an assessment of whether there's a legitimate business interest and whether there's at least a less discriminatory alternative response.
I hear what you're saying. I just fear that the top half, that the second portion, subsection B, I fear that it claws back the rights that you give in subsection A. But I'm happy to talk to the sponsor offline and continue to work on it.
So
I just want to add
Delegate, I want to be sensitive that we have a number of other delegates that need to get back to their committee.
Yes.
And that technically we're sponsor only, and we're kind of stretching that a little bit here. So let me go to Senator West, and then we can make sure we.
And we could talk offline.
Absolutely.
I mean, I just want to make a point that there is
Senator
no
West,
new
go ahead.
legislation.
I don't want to prolong things. I had concerns along the same lines as Senator Henson did. So I'm looking at the Attorney General's letter, which says that a policy, for example, prohibiting renting to tenants who have a felony conviction on their record, regardless of the offense or how long ago, may discriminate against Black tenants because of the race bias built in the criminal justice system. Most landlords want a building in which the tenants are not going to aggravate each other. In other words, they don't want a tenant who's going to be a source of problems in the building, and they'd rather screen to prevent people like that from being rented to in the first place. So that's why landlords take a look at criminal records. They, for example, would not want an arsonist in the building. They would not want a sex offender in the building. They wouldn't want someone convicted of a hate crime in the building. That all seems to be totally acceptable. But what this bill seems to do, and I want you to tell me why I'm wrong, is to put landlords at their peril. If they screen people for criminal activity that could offend other fellow tenants in the building and keep them out, they could find themselves being accused of discrimination as a result of this bill. Is that what you're trying to do?
So let's just be clear that we're not requesting anything new here. This is current federal law.
You're taking the intent element out of the crime. That's new.
No, the current federal law exists right now and was proven in the Supreme Court under Texas Department of Housing and Community Affairs versus Inclusive Community Project in 2015, that says that disparate impact theory is a valid claim under the Fair Housing Act of 1968.
Okay.
This
Thank you
is-
for your answer.
Okay, we just wanted it at the Maryland level because Project 2025 could dismantle that at the federal level. And they already have under the previous administration when Carson was the administrator. So we're just trying to make sure.
So the inclusive communities case, from what I recall, it was about how tax credits were divvied up in the state of Texas. And
Yes.
they were taking these low-income housing tax credits and essentially ghettoizing or concentrating.
That's right.
People.
That's right.
And so, I remember this because I work for an affordable housing company, and I remember looking, and there was affordable housing advocates versus fair housing advocates. And so you had two white hat kind of groups kind of dealing with one another.
Exactly.
And the idea about disparate impact was, again, the state of Texas wasn't intending on this discriminatory act happening of this concentrating of poverty.
But it was happening.
But that's what was going on.
So it's
And
regardless
that's what
of
the
intent.
Supreme Court then said, no. So your legislation, what it's attempting to do is to codify inclusive communities. So it's not anything groundbreaking that you're trying to do.
No, we're just trying to employ the federal standard at the state. Because if we lose the opportunity to sue under the Fair Housing Act at the federal level, we have to institute it at the state level so that we could be able to protect individuals in the same way.
And we already know that at the federal level, they're trying to get rid of any type of disparate impact types of.
And they did that under the previous administration. Exactly. And thank you for that question.
All right, further questions from the committee? All right, seeing none, thank you very much.
Thank you. Yes.
All right, that will conclude the hearing for House Bill 1239. Are there any members of HGO still here? Okay. So then we're going to move on to, so Delegate Embry has been waiting for a long time, and then Buckles next, and then we'll go back. And then I see Lewis is here, so we'll go to Embry, then Buckle. Yep, back there. Yes. Is Teresa on HGO?
Oh.
Okay. Okay, yeah. I was mistaken though, but Embry got here earlier, so I want to make sure we get you. Okay. No.
Thank you, Chair, very much. And my witness, may he join? We have one witness. Thank you so much. It's very nice to be back, and I appreciate all of your time. Elizabeth Embry, District 43A. As you may recall, and Senator Sidnor mentioned this earlier, a version of this bill was passed last year by the House and Senate. And that version allowed all estate notices to be published on the central website created and maintained by the Registers of Wills. That bill was vetoed by the governor because representatives of the press did not testify and were not involved last year. So this year they did participate in the judiciary hearing and in multiple subcommittee hearings. And the bill that you have before you is the result of those conversations. And I'll talk about that in a minute, but I just want to give a refresher on the background of this bill. The notice that this applies to, or notices that are the subject of the bill, they exist solely to reach two categories of people: creditors. They're generated by the the processes required when an estate is opened to reach creditors and beneficiaries. They're not to alert the public generally, it's just to reach those two categories. And it's almost a catch-all because the registers have to send notice to everyone, every party to the estate. So this is sort of a, if you didn't receive the mail, here's one more chance to get you. But those are the two audiences. And the notice has to be paid by the family or the person representing the family who has died. So it comes out of their pocket. It runs between $100 and $300, sometimes more in areas where there's only a single paper, so there's a monopoly. So the charge can be even higher, and it's expense that we require of families that predates the internet. And it's really, at this point, there's no policy justification for it. The centralized website that exists and is, I think, the top search on Google that is all the registers of wills participate in. It's free of charge, entirely free of charge. Creditors like it because you can do a Google alert. It's one place. And families may be scattered. We no longer have, families that live always within a single county. People move across the country, across the world. And so having a single site is also useful for them. And also, I'll just note, because the notice is controlled and posted by the registers, there are fewer errors, there's fewer issues, and of course there's none of the payment delays and problems. So the amendments to the bill. So we've amended the bill because we are respectful of the financial impact to the newspaper industry, which is a $1.4 million statewide impact. So the bill, now it would apply, meaning that this category would be able to just use the website, would not have to pay for notice, if the decedent's heirs are limited to a spouse, a registered domestic partner, a lineal ancestor, and lineal descendants. And so in that category, as the original bill did, it would require the notice to be printed for free on the website, and all other categories would still be printed in a newspaper as is currently occurring. We also added a reporting requirement so that we can keep track formally of whether this cost that we impose on families actually has an impact. Because the registers testified in the House, and Mr. McFarland may testify today, they have no record of anyone ever coming forward as a result of these newspaper publications. So hundreds of dollars per family, no one has ever come forward that was not reached through the normal means of receiving mail or just knowing about it because they're close to their family. And the final note I want to make, final context, is the DLS librarians, who are phenomenal, provided all the sites in the Maryland Code where we require printed newspaper notice. And there's 190 locations. Overwhelmingly, 160 of those are requirements on state agencies. So it's borne by taxpayers, not individuals. The remainder are mostly borne by businesses who are seeking to take some action. And this very, very, very small category is borne by individuals. So this is not upending the entire system. This is just trying to protect Marylanders from having to pay money at the moment that they're dealing with grief and process and really complicated, awful things. So again, we are very sympathetic to the loss in revenue, but that is not a justification for imposing unnecessary costs on individuals and their families. And I hope you will again vote favorably on this bill. Thank you.
Good afternoon, Mr. Chairman, members of the committee, and thank you, Delegate Embry. My name is Byron McFarland, Register of Wills for Howard County. On behalf of the Maryland Register of Wills Association, we ask for a favorable report on House Bill 623. I want to build on some of what Delegate Embry said and just sort of run through our case as succinctly as possible. First, we need to protect due process in probate. Under current law and under this bill, every interested person in an estate in Maryland has and will receive a notice directly from the Register of Wills to their home address, informing them of their rights. This is an affirmative duty of the state through the registers. The newspapers have no duty to inform and no duty to provide that kind of notice. Two, we should be making probate more efficient and fairer for Maryland families. The print notice publication this bill will substantially reduce, which has been Maryland law not just since before the internet, but before the telephone was invented, will save people time and money. Not all newspapers publish daily. Many newspapers make chronic errors that require republication, which delays probate and delays distribution of assets and closure for families. Three, we shouldn't be nickel and diming people in grief. Many papers require families to pay these notices out of pocket before they have been appointed and have access to estate funds. And some of these notices do cost over $300. Four, the fundamental truth here is that no one reads these notices. Five, Taxpayers should not be paying the registers of wills. Our office is to play the roles of copy editor and bill collector, which we do in many jurisdictions. A lot of publications will not publish notice until we collect the payment for them. That should not be our responsibility as the state. And lastly, while the registers and our coalition partners, including the Bar Association and the AARP, believe strongly in the bill in the original form. As Delegate Embry said, we do understand that when you are changing longstanding law, sometimes compromise is required, and so we support the bill as amended. Thank you.
Thank you both very much. Questions from the committee? Senator West. Oh, I knew you were.
Oh, well, I wasn't going to ask, but as long as my light is on, let me ask the Register of Wills this question. So I've always assumed that organizations like Visa or MasterCard reads these things, because otherwise they would not be aware that someone has died who owes them money. But you say nobody ever reads these. So how does Visa find out that someone who owes them money has passed away?
I'll tell you that in our experience, creditors are really good at finding people who owe them money. They're exception. I mean, most claims that are filed by debt collectors, it's mostly out-of-state debt collectors. They find out very quickly. Most claims against estates are filed within the first couple of weeks after they've passed away. We actually have claims filed against estates before the estate is even opened. And they find out about it either because of, I mean, a big part of it is our website. You know, these debt collectors, a lot of them.
Your website?
Our website,
Yours
yes.
was, okay.
And a lot of these debt collectors, you know, they're located out of state. They're not subscribing to the Cecil Whig or the Dorchester Star. They're going to our website. We know that. And this website, when we decided to develop it, this was incorporated into the existing cost of our IT contract, and we would not have any savings if we didn't have it. So we've heard from the other side that the public is paying for it. No, we're not. This was incorporated into existing expenses.
So everybody in the state who files, or whose personal representative files with the Register of Wills is on your website?
Yes, in perpetuity.
Got you. Interesting. So, yeah. Okay.
You could go on to Senator.
That makes a lot of sense. Sure. If I was Visa, I wouldn't try to subscribe to all the little local newspapers. I would just view your website daily and and cross-check my records to see if somebody who owed me money had passed away.
Absolutely.
Okay. Great. Thanks.
All right. Further questions from the committee? All right. Thank you both very much. Thank you.
Thank you.
All right. Ms. Snyder, welcome.
Good afternoon, committee. I'm Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware DC Press Association, and we stand in very strong opposition to House Bill 623. A couple reasons why. There are 190 statutorily required public notices. All of them serve the community. And although this bill feels like only heirs and creditors deserve to know about what's happening in the community, estate notices do belong to the community. So it's a really stark philosophical difference about whether or not government should be policing itself and placing notices on their own websites, or whether it should be in an independent entity such as newspapers, where it has always been. Secondly, the amended bill that's standing before you, I in no way want to intimate that we were a party or in discussions about that amended bill. That amended bill came out. We were not involved in how that happened. We are still opposed. Today, you have a strong choice before you. Do you want to have a seismic change in the landscape of news media? And you have testimony behind my testimony from local publications like the Hancock News, like the Baltimore Sun, like the Baltimore Jewish Times, like the Daily Record, that are telling you from a business perspective, stacked up against every single tax, every single difficult choice the legislature is making, that they are going to be radically changed by this bill. Is it worth it? Sure, maybe some publications charge $300. Most, on average, charge $129. Many charge $60. Free is not free. The Register of Wills developed this website of their own volition. The Press Association maintains a publicly available free website that has every notice from our members on it already. There was no support, and I'm just going to say we're unfavorable. I am happy to wax poetic about this for a really long time because it's a huge life and death issue for your local media. Thank you.
Thank you very much. You said there is a free source of information for these types of...
I want to make sure that I'm not speaking out of school. So the members of the public, if you're opening a state, yes, you're going to pay a publication fee. At some point, the registers are going to need to make sure that they can maintain their website. Private entities, newspapers do that now. There is a charge to the public to place that notice because it's a service. There is, for most of our newspapers, and I don't get into their business practices, but we encourage everyone to put their public notices in front of the paywall, and the Press Association maintains a collaborative website of all notices that members upload, and that is free to the public.
Now, in this encouragement, do most of your members put these things in front of the paywall?
100%, yes.
100%. Thank you.
All right, further questions from the committee? All right, thank you very much. With that, that'll end the hearing for House Bill 623. We'll now move on to Delegate Buckle with House Bill 860.
Good afternoon, Mr. Chairman. I like looking around here. I think I served in the House with every single member currently sitting here today. And all of you are wonderful people, except for one that I was forced to sit next to for several years in the Ways and Means Committee, and he knows who he is. Good to see you, Senator Charles. Thank you very much. House Bill 860 is a bill that essentially would expand duties for common carriers and would really include them to be within our public nuisance law very specifically for when their actions cause damage to our public infrastructure, most importantly bridges and roads. I'm disappointed Senator McKay, I'm sure, had another bill or something that he left the room at the time, but the genesis of this, it would apply statewide, but the genesis of it actually occurred within a block of Senator McKay's home in Cumberland, Maryland. About 7 years ago, I said 7, between 7 and 8, the CSX Transportation Company, which is a major employer not only statewide, but in our region, in Cumberland, it has a very large rail yard. Their trains hit not one, not two, but 3 bridges that are actually roads. They're bridges, underpasses for the railroad, but they are roads that cars travel through to a neighborhood. One of them less than a block, I think, from Senator McKay's home. I think you can look out his door and see it. 7 to 8 years later, we still sit that none of those roads, except for one lane of one of the roads, are open to traffic because these things are very, very complicated. It took years to figure out, quote unquote, who owned the bridges, who owned the streets. The same situation applied. Ellicott City, I think years ago, had a train that hit a bridge/street. And because a lot of these things were publicly dedicated back in the late 1800s, early 1900s, it was very difficult to determine. It took years to assess the damage and to assess the potential liabilities. What this bill does is it creates what we call as lawyers an ongoing nuisance. If you hit it and you broke it and you don't fix it and it stays broken, you're liable for the ongoing nuisance until it gets fixed. It was a bill that I believe was approved unanimously or close to unanimously in the House. And that's sort of what happened. What happened and is still happening on the west side of Cumberland, if it happened in, I believe, any of your communities, would be a daily news story of significant concern because it impedes emergency services, ambulances, fire trucks, things of that nature that now literally, because these bridges are sort of, the streets are sort of stacked up in a row, it creates a significant public safety hazard. And we think that this bill will in the future prevent these types of things from happening and will encourage common carriers, railroad companies in particular, to take a hard look at their activities. And if they cause these damages through acts of negligence, incidents that happen, they'll be right there to make sure that they get fixed appropriately and quickly rather than simply punt it down the road for years to come. That would be the conclusion of my testimony today, and thank you for the opportunity to be here.
Thank you for bringing the bill, and it's a good bill. I know you're focused on railroads. When I served with you, I cross-filed with Senator Ferguson, the bill to legalize rideshare in Maryland. And we purposely didn't put rideshare, Lyft, and Uber as common carriers. We defined it as a separate. This puts them as common carriers. Would you be averse, given the focus on railroads, to taking
I think
them
they
out?
should be taken out.
Okay.
I think this isn't intended for people that are just, it's a rideshare company and they the driver bumped into a bridge or whatever it is and wasn't really within the control of the company to fix. I think they should be taken out. Yes.
Thank you, Mr. Chair. You know, I have to get some questions out of my former seatmate. And,
I taught him everything he knows,
in ways
Mr. Chairman, believe me.
Oh, it's your fault.
It's definitely
I knew that would come too.
No, so you mentioned CSX and my monthly meeting that I do with MDOT and DPWT. For the last year, we've been going back and forth on the issue with CSX. So they've damaged the road on Hall Road in Prince George's County. And so we're trying to work with them to address that issue. Will this bill allow you to go back in time for issues that have been
I think so. I think certainly CSX's lawyers, I used to be one of CSX's lawyers in a prior life. I'm sure that they will present whatever arguments that they want to present, but I think your community is probably facing the same issue that we faced. It's very hard to get some of these common carriers, large companies, to step forward and fix what they broke within the time limits currently allowed. And we're all trying to work collaboratively in the beginning. We're trying to say, well, there might be federal funds, there might be state funds, will CSX pay, or will Norfolk Southern, whoever it is. And what happens is that it just keeps getting punted down the road, and then there's no redress, there's no remedy.
Yeah, I know we have a meeting coming up with them next month to address this issue, but it's been like going back and forth for over a year. But I appreciate the bill, and it's always good to see you.
Yeah, I'd like a favorable vote, especially from you.
All right. Further questions from the committee? All right. Thank you very much.
Thank you very much. I appreciate the time.
Excellent. With that, that'll conclude the hearing for House Bill 860. We'll now move on to Delegate Terrassa, which is House Bill 1076, and then Delegate Lewis.
Good afternoon, Chair Smith, Vice Chair Waltrinker, and esteemed members of the Judicial Proceedings Committee. For the record, I'm Delegate Jen Terrassa, and thank you for this opportunity to present HB 1076, which protects tenants and makes landlord-tenant interactions more predictable by specifying when landlords are allowed to access a tenant's premises, what notice is required. And before I get into this, I just wanted to note that the bill was amended in the House to address the concerns of the realtors and MMHA, and my understanding is they're no longer opposed. So what problem is this bill trying to solve? When a landlord rents a property out, they contractually grant the tenant the exclusive right to occupy the property, and the tenant reasonably believes they are entitled to the privacy in their own homes, just like you are. Obviously, there's some situations a landlord might need to enter a rental property. For example, it makes sense for a landlord to enter an emergency for health, safety, and welfare of the tenants or other tenants and staff, or to make repairs, do maintenance, inspections, or show the unit to a prospective tenant or buyer. Other than in emergency circumstances, though, such visits are generally not of an urgent nature and can and should be scheduled in advance, and the tenant should be given reasonable notice. Landlords know this, and some even include those provisions in their leases. Some counties, for example, Prince George's County, have laws that cover this. However, Maryland does not have a statewide law that addresses this gap in the law. And this gap in the law can lead to problems that range from inconvenient to awkward to completely inappropriate. So, for example, folks might be in the middle of family meal or bedtime routine or having a work meeting or date night. Even more disturbing, though, are accounts that some landlords who suspiciously enter property repeatedly when a lone female tenant is showering or undressed. So here are 3 recent incidences in which tenants experienced unannounced landlord entries that I understand are surprisingly common. One tenant who lives in a larger building, her manager gave out copies of her keys to prospective tenants and let these strangers enter the tenant's unit without any notice. The tenant was shocked to see strange men let themselves into her apartment with the keys provided by the property manager. Another landlord would knock once and come in immediately after knocking if the tenant did not respond. One time, when the tenant wasn't at home, the landlord came in when her two underage 18 children were undressed and changing. Another account came from a tenant who lives in the basement of her landlord's house. The landlord would let herself into the basement without notice frequently, but on one occasion, the landlord let herself in to the tenant's unit to supposedly inspect for needed repairs while the tenant was in the shower. The tenant was shocked to find her landlord in the living room when she came out of the shower. So beyond inconvenience, outright inappropriateness, or even danger, a major problem with this lack of clarity in the law is it allows landlords to raise as a defense in a rent escrow case the tenant's supposed refusal to allow the landlord entry onto the property. And this interferes with one of the few remedies tenants have when a landlord refuses to do necessary repairs, which is escrowing rent money. And it gives unscrupulous landlords an excuse for that inaction. So how does 1076 address this problem? It will help landlords and tenants avoid this kind of conflict by setting clear standards of notice and acceptable purposes for entry. It does this by specifying that landlords can only enter leased premises in the event of an emergency or if the tenant gives specific permission to enter the property sooner. And in all other such situations, such as maintenance or repair, or to show a soon-to-be vacated unit to potential renters, the tenant has to be given notice of 24 hours in advance, and the landlord may only enter between 7 a.m. and 7 p.m. Out of 50 states and the District of Columbia, 38 jurisdictions have laws addressing when a landlord may enter rented property, and these laws, and they have these laws because they simply make sense. It's time for Maryland to join them. I respectfully urge a favorable report on House Bill 1076.
Mr. Chair, I've been getting lobbied on this evictions bill recently, and so one of the things I noticed and that we had some conversations with some of the advocacy groups is the paper notice attached. I feel like the email and text message probably should also be associated with the other bill as well.
Okay, so on the other bill?
Yeah, it's another bill, but is there a way to tie in? Would you be open to tie in this type of notice for adding evictions as well to this?
On the other bill?
No, in this particular bill, would you be open?
Oh,
to
I'm
adding-
sorry. You're saying you want to see the notice that's
Like
in?
when a landlord can actually come into a house, you got to give 24-hour notice before the eviction that they post that they'll be in the house at a particular time. Is that the multi-rule or multi-subject issue?
You're trying to change the way the notice is given? Is that what you're saying on this?
Well, there's already a notice of 10 days for evictions, but I'm just looking at how it's in here. I think it just adds some more clarity, giving folks notice before somebody goes in with the emails and the text message in addition to putting the paper notice affixed to the door. So I'm just wondering if we should add that in, but we can talk offline.
Yeah, I'd be more than happy to talk
Yeah.
offline with you and make
Okay.
sure that that's appropriate notice. Absolutely.
I think folks just need to have, all issues, have as much notice as possible.
I completely agree with you.
Okay, thank you.
And thank you to the bill sponsor. I love this bill. You highlighted some really important scenarios of where it would be necessary and a real good protection. My only question is, sometimes there are circumstances where the landlord enters the unit based on the potential safety of the tenant. They might be assisting with a wellness check or something of that nature. Would you be opposed to the language that talks about emergency circumstances, talks about the safety and welfare of other tenants and staff? Would you be opposed to something that also included the tenant for that unit and not just other tenants?
Oh, if that's not in there, it's intended to be in there, absolutely. So it originally said that for the safety of the tenant that was in the building, and then we were adding other tenants or staff. But if it doesn't say that, absolutely.
Thank you. I appreciate it, and thanks for bringing the bill.
Thank you.
Excellent. Thank you very much. All right, questions, further questions from the committee? All right, seeing none, thank you very much.
Thank you very much.
Thank you. All right, that'll conclude the hearing for House Bill 1076. We'll now move on to Delegate Lewis with House Bill 1440.
Thank you, Mr. Chair, Mr. Vice Chair, members of Judicial Proceedings. Great to come before you. This is a unique moment in that I'm before you without a transit bill. I'm actually before you with a civic engagement and health bill that honors family life. So House Bill 1440, this is a bill, as amended, will strengthen the ability of Marylanders to participate in civic life through jury service, while also honoring and respecting the needs of breastfeeding, nursing, and child care providing adults. So here's how the bill works. First, it requires circuit courts that are renovating or in new construction to provide a lactation room with specific criteria and characteristics for public health and safety of breastfeeding and nursing mothers and parents. Secondly, the bill creates a new category for excusal from jury service, and that is excusal for the purpose of breastfeeding, or nursing, or caring for a child under the age of 3. Third, the bill requires, as amended, requires the circuit court system to provide an annual report to the Governor and General Assembly, reporting the number of lactation and child care requests for excusal, the number of such requests that were granted and declined, and disaggregates that data by jurisdiction. Lastly, the bill does something unique. It actually defines in state law what breastfeeding is. And that was a thing we discovered that we had to do. I'll mention that this is one of the many fantastic legislative proposals that comes out of the ideas of our constituents. My constituent, Miss Rachel Wagner, who had some experience of being called to jury duty and also heard many stories of her friends who'd been called to jury duty while breastfeeding postpartum and who were denied excusal, thought this was something really important that we could actually fix. The bill has no fiscal note. It models, to some degree or other, provisions that are provided by 22 other states. It has a nominal fiscal note, a one-time fiscal note of $25,000, which really relates more to administrative setup. And with that, I'd ask for your favorable report for a bill that really brings us back home to nuts and bolts of governance, which is making it easy for our constituents to engage in civic life with respect and dignity. Thank you.
Excellent. Thank you very much. Questions from the committee? All right. Seeing none, thank you.
Thanks so much.
Good to see you, Delegate. Thank you. All right. That'll conclude the hearing for House Bill 1440. We'll now move on to Delegate Taylor with House Bill 1151.
Thank you, Mr. Chair. Good afternoon, Chair Smith and members of the Judicial Proceedings Committee. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. I am here today to introduce House Bill 1151, which seeks to create a reconsideration of value process as recommended by the Task Force on Property Appraisal and Valuation Equity. Appraisals play a critical role in the home buying process, yet countless studies have shown that properties in Black communities are consistently undervalued compared to similar homes in predominantly white neighborhoods. These inequities not only affect individual homeowners, but also contribute to broader disparities in wealth accumulation and neighborhood investment. This bill has been amended which adds depth and provides clarity for potential reconsideration of value scenarios. I appreciate the input and suggestions from the Appraisal Institute, the Maryland Mortgage Association, and the Maryland Realtors. I have incorporated some of their recommended language in the extensive amendment. I have also met with Mr. Enton from the Bankers Association and am strongly considering their proposed language adjustment. In summary, when there's a sales transaction, House Bill 1151 provides the ability of the seller or seller's agent to provide additional market data or comps as requested by a lender or lender's appraiser, if the appraisal falls below the contract price. Number 2, home equity line of credit or refinance transaction scenario. House Bill 1151 gives an owner or the owner's representative the right to provide additional market data or comps if the appraised value falls short of the expected appraised value. I urge the committee to support House Bill 1151, which is a Black Caucus priority, and by voting favorable, you are helping to ensure that all Maryland homeowners receive fair and accurate property valuations. Thank you.
Thank you, Mr. Chair. You said that you're giving consideration to Bob Enton's suggested amendment.
I am.
I don't think we've seen that. Can we get?
I talked with Mr. Enton this morning. And there are a couple of paragraphs. I can point to the couple of paragraphs if you like.
Sure. I've got the bill
I'm
here.
sure he's going to go over them himself. Section A 14104.2 A1, seller or seller's agent may at any time during the sales process provide to an appraiser, making an appraiser, Their suggestion is that we delete that paragraph. And I think the reasoning behind that.
So discuss that, it's merely a may, and we don't need a statute to say that you may do such and such, right? So I can understand why he would suggest that be deleted.
Could be that, or we don't want to interfere with the integrity of the process of appraising.
Right, okay. So his suggestion is that A1 come out.
His suggestion is A1 come out and A2.
Okay. Does he have other suggestions?
Absolutely, and I'm not sure if I'm going to go through all of those here, but yes, there's some rewording, and once we are able to incorporate that, and maybe I can work with the committee counsel on those amendments, you'll get a chance to see the reprint at that point.
Okay. The reason I'm asking is because I had the same idea that we should get rid of A1 and A2. I've got some other ideas. I don't want to just reiterate what Mr. Enton says. Let's go down to towards the end. It says in subpart D, a written copy of an appraisal or reconsideration shall be provided by the lender to the requesting party at no cost to the requesting party. The requesting party is never defined. Does that mean anybody could come and go to a lender and say, I'd like copies of all the appraisals that you've arranged for the last 5 years, and receive copies of all those appraisals at no cost?
So let's go to section line 13 and 14, requesting party. I think that's entirely appropriate. Requesting party. The requesting party would be either the buyer
or... Who's the
or...
requesting party? It's not a defined term.
It's not a defined term in statute?
Or in your bill. I don't know about the statute. If it's a defined term in the underlying statute, that would be one thing, but there's no defined term in the bill.
Okay.
So there's a question.
I think Mr. Enton has the same question.
Does he?
He does.
Okay, well, that makes sense.
Yep.
And then higher up on page 3 of the bill, where it says an appraiser who receives additional information shall also consider a cost approach. These days, do appraisers really use cost approach? The sort of the received wisdom in the real estate industry is that the value of a property is dependent on location, location, location. So you could spend the same amount of money building the same house in an extremely desirable location or in the middle of a crime-ridden area, and the value would be entirely different based on what area the house is built in, irrespective of its cost. So why do you think requiring the appraiser to go back and reappraise the property based on cost would be desirable?
So I have two answers to that. One is location, location, location. And sometimes a desirable location are those that were not affected by redlining laws that were very prevalent in the mid-1900s through the 1970s. So I consider where I live a very desirable location. However, if my home was in Montgomery County, it would be worth $1 million more. That affects the wealth of my family, my ability to provide for my long-term care, et cetera, et cetera. Now, this recommendation came from the task force on valuation equity, the task force on property appraisal and valuation equity. They met for a year, very, very competent folks, and these are their recommendations. Now, from what I understand, because I asked the same question about the cost approach, are appraisers still doing a cost approach when they're in their appraisal? And I was told that yes, it's not hard to do, and quite frankly, it happens during appraisal. Like, they have the ability to do the cost approach as well.
I would love to hear from an appraiser on that. I would think that estimating the cost of rebuilding my house from scratch
That's different.
would be, well, that's the cost approach. How much would it cost to build the house, right? I would assume that would be a sophisticated process of trying to figure that out based on square footage and lots of other considerations, and totally different from what appraisers do, which is look at comparable sales in the area in recent months and then figure what this property would sell for based on comparable sales in that neighborhood.
Senator, I'm not an appraiser, but from what I understand, your definition of the cost approach is not accurate.
Really?
The cost approach is not necessarily what it takes to rebuild your house. Now, from there's perspective insurance, maybe, but not from the perspective of an appraisal. But yeah, we probably should talk to an appraiser about that for sure.
Okay.
Yeah.
All right. If you would, when time permits, find a copy of Mr. Enton's proposed amendments and maybe provide them to the committee, and let us know
For
whether or
sure.
not you agree to them or disagree with them.
For
It would be
sure.
helpful.
For sure.
Thanks.
You're welcome.
Good afternoon, delegate. Welcome, welcome, welcome to the committee.
Thank you.
I'm going to ask a personal question to you. When you built your house in Bowie, how much did it cost for you to build your house?
So I didn't build my house. I bought my house. But I'll tell you a quick story. As HOA president in my neighborhood, I got a call back in 2020 from one of the lot owners who was about to build their house. And he called and he said, is it normal that I would pay more to build my house than it appraises for? At the time, I didn't know because I didn't build. So I asked, actually, Delegate Holmes, some others from Maryland Association of Realtors, Fair Housing Alliance. We eventually started a group called the Fair and Unbiased Appraisal Advocates. We had town halls, which led Marvin Holmes to propose a bill that created the task force. And the task force has finished its work, and they've had 5 or 6 different recommendations, and I've taken on a few of those. But in Prince George's, and when you're building, especially when you're building a custom home, no matter where you are, sometimes you are paying more to build than your home appraises for. Not only that, but you might find that the rate of appreciation is much slower than it would be if it was somewhere else in another zip code in Maryland.
So it's fair to say that $1 million was possibly spent on this house being built and it appraised for $800,000.
In this case, the disparity was even greater.
And if that person wanted to sell that particular property and they spent $1 million and it's being appraised at 100, and they wanted to be able to provide information such in Section A1 that I believe Bob Enton wants to remove, and they wanted to provide that information to say it actually cost $1 million with all of the material, the labor costs, this is how much it costs to build that house, this custom home, that will take the ability to provide this information to the actual appraiser during the appraisal process. It's looking like I'm trying to keep up with the bill and read through, but I don't want to put us in a situation where the appropriate information that can be provided can't be provided.
Thank you for that. Even if we delete A1, A3 still has, shall also consider a cost approach as a part of the reconsideration of value. So it's still there. Okay. So we don't lose that ability.
Okay.
So you have the cost approach engineered in there.
No,
or considered.
I appreciate that. I know the SStat guidebook states the closer your home is to a urban center or the water, the more valuable your property is. And when you look at our homes in Prince George's County that are in Suitland and Forestville and Capitol Heights that are right across the line from DC, and those homes are being sold for $2 million or $1.5 million, the closest urban center, and then you look at our homes in the Inner Beltway being appraised at $300,000.
Yep.
There's a huge discrepancy, a huge issue, and it's a lot of wealth being stolen from our communities because sometimes these appraisers don't follow the guidelines that's in the SStat guidebook that allows them to know how appraisals are even done. So I want to make sure we are being protective of the language in this bill, and based off of what your answer was, we are.
I think so.
All right, thank you.
Thank you.
All right, further questions from the committee? All right, thank you very much, Delegate. Thank you. All right, we're now going to hear from the opposition panel, and Mr. Richards will come on up.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Evan Richards. I'm the head of government affairs for the Maryland Bankers Association. Instead of Mr. Enton, you're stuck with me today. Just walking through the bill here, let me pull out. Obviously, combating appraisal bias is important. Well, even though we're signed up unfavorable, a lot of the concepts in here we truly understand and we think they're important. That's the task force that the bill sponsor mentioned. Actually highlighted a method that can be used to combat appraisal bias, and it's already being used by the Veterans Administration, called the Tidewater Initiative, where you actually have the opportunity to submit information to the lender, who then shares with the appraiser if the appraised value comes in under the contract price. So that you have that process that's already been established and is already being used. Senator West, I'd like to invite you to become an honorary member of the Maryland Bankers Association, because a lot of your concerns, you nailed that head on. Obviously, Section A, it's important for the seller to be able to communicate with the appraiser, especially in the cases where the appraiser has questions about the property. So there's nothing in statute that's prohibiting a seller from communicating with an appraiser, but they have to be careful in doing so, because if not, they could run the risk of unduly influencing the appraisal. So, Section A, what we're looking at is really, striking that, because of the fact that in Section B, there is a process laid out where the appraiser, actually similar to the Tidewater Initiative, where the where the appraiser would have to notify the lender, and you work down the process, and then the buyer and the seller have the ability to go back and send information to the lender for reconsideration.
Mr. Chair, so I received some information that HUD just last week issued new regulations which are inconsistent with the provisions of this bill. Are you familiar with those new regulations?
What I'm not familiar with HUD regulations. What I'm familiar with is the fact that, a lot of the federal housing authorities did have guidance that was issued for a reconsideration of value process that lenders were to follow, and that was actually withdrawn by the administration last week.
Okay. I've asked for a copy. Do you have them? Okay, great. So the committee has copies of those regulations. We can take a look at them. And I was also advised that in light of those regulations, the Maryland Realtors changed their position on this bill to oppose the bill now. Are you aware of that?
No.
Okay, thanks.
All right, thank you very much. All right. With that, that'll conclude the hearing for House Bill 1151. Is Delegate Long here? Oh, okay. Oh, actually, what's going on? You signed up? Sorry, come on up.
Good afternoon, members of the committee, Mr. Chair, Mr. Vice Chair. My name is Richard Green. I'm with the Maryland Mortgage Bankers and Brokers Association, and I'm here in opposition of House Bill 1151. The bill clearly, while well-intended, does not fit industry standards in really any way, shape, or form at this point. As amended, there were many things that were taken out of the bill which made it certainly a little bit more palatable. But I'd like to go through just a couple of points. And Senator West addressed some of them in his questions. Number one, the requesting party is too wide open, needs to be defined. We cannot give an appraisal out to anyone other than a buyer. It is owned by the lender.
Sir, I was just saying.
The chairman's trying to ask you to pause for a minute while he says something.
Yes, thank you. Sorry, I appreciate that. Thank you, Senator. I actually don't have you signed up. So I don't want to put this in a posture where we have two people opposing and because we had one up. I wonder if you could just meet with folks individually. I want to make sure we maintain balance. And I only had one person signed up in opposition, one person in favor. So I want to just make sure we keep that in balance.
My apologies. I'm having a difficult time hearing what you're saying.
Sure. Unfortunately, we had, for these limited hearings, we have one person sign up in opposition and one person sign up as a proponent. And to maintain balance, I want to make sure that we keep that balance. And there are not two people sign up as a proponent. So I want to make sure that we are in receipt of your testimony, but that we don't have an imbalanced or unbalanced hearing. So with that, my apologies. I want to make sure that we just maintain balance. Okay. Thank you. Okay. Thank you. Thank you, Senator James. Okay. With that, we're going to go on to House Bill 756, and that's Delegate Long's representative.
Good afternoon, Mr. Chair. For the record, my name is Cameron Gross, Legislative Director for Delegate Jeff Long, who couldn't be here today due to the death of his grandfather, and I ask that we all keep him in our thoughts and prayers at this hard time for him and his family. This is my second time in JPR today. I was here yesterday for him as well. Thank you for the opportunity to present House Bill 756, Petition for Guardianship of Property of Alleged Disabled Persons, State of Civil Actions and Proceedings. This legislation is aimed to enhance the adult guardianship process in our state. As we deliberate on this crucial matter, we must consider the impact such legislation has on the lives of the most vulnerable Marylanders who require legal protection and support. The proposed legislation seeks to introduce a temporary stay provision like the automatic stay observed in bankruptcy proceedings. Much like bankruptcy stay, this provision would offer a critical break to individuals facing financial and housing crises due to their disabilities. This would temporarily halt eviction proceedings and creditor actions, allowing these individuals to have a court-appointed guardian manage their finances and affairs until a more permanent solution is reached. Allow me to illustrate just one real-life issue that we have seen this in. Excuse me. Consider a case of individual A who is diagnosed with dementia, who has faced loss, who is facing the loss of their home due to unpaid taxes. Despite having a significant equity and resources to rectify the situation, individual A's cognitive impairedness prevents them from acting upon this. The absence of a temporary stay provision led to the unfortunate sale of this constituent's home. Had such provision been in place, a court-appointed guardian could have intervened, preventing the loss of the home and safeguarding individual A's assets. This example shows the urgent need for this legislative measure that prioritizes the protection and rights of individuals with disabilities. The proposed legislation offers a lifeline to those who find themselves entangled in a legal proceeding they're ill-equipped to navigate alone. It is crucial to emphasize that this temporary stay provision does not unduly burden landlords or creditors. Instead, it serves as a compassionate and pragmatic response to complex situations, safeguarding the interests of all parties involved. With that, I urge a favorable report on House Bill 756. Thank you.
Thank you, Mr. Chair. I'm sorry the delegate can't be here, and it's really probably unfair to ask you questions. And let me just say that I think the bill is well-intentioned and gets at something that needs addressing. I think the bill has serious problems. For example, it's all premised on a petition for guardianship of an alleged disabled person. So there's no requirement in the bill that whoever is alleged to be disabled be found to be disabled. And next, it seems to assume that once the request for the stay is made, that the court has granted the stay. But it doesn't provide any standards governing the grant of such a stay, on what basis a stay should be granted. It can't merely be because someone is alleged to be disabled, and therefore you get 90 days. Which is what the bill seems to provide. And so it's unfair to ask you to answer these questions, but I think we need to work on the bill and work out these bugs in order to make the bill a bill that will work in real life. But thanks so much for bringing the bill to us.
Well, Senator, I can definitely follow back up with you on the delegate's perspective later on today once I talk to him about it.
Yeah, and given his circumstances, I wouldn't worry about getting it to us today.
I got you.
It's just sometime in the near future, we can work with him on the bill. We've still got a couple of days before Sonny died to get this worked out. Thank you.
Hey, thanks a lot. Appreciate that. All right, thank you very much. With that, that'll conclude the hearing for House Bill 756. Is Delegate Chow Wu here for the Howard County delegation, or is anyone else here for the Howard County delegation for House Bill 808? Okay. All right, so then we will just enter into the record for House Bill 808. We'll review it and consider it later on. With that, that will conclude our bill hearings for the day. We'll now move, I'm going to gavel out. We're going to take a, let's call it a 10-minute break, and then we're going to come back and vote. And I know some members probably still have bills across the street as well, so we'll try to vote as soon as possible and then head over there. Okay? See you all in a bit. All right, good afternoon, everyone. Welcome back to the Judicial Proceedings Committee. We are back for our second voting session of the day. We are on voting list number 20, and we are going to start off with Senate Bill 808.
Senate Bill 808 modifies provisions of Chapter 678 of 2024, which authorize the use of stop sign monitoring systems in Prince George's County and school zones, to also authorize the use of such systems at school bus stops in the county. There are 3 amendments in your packet. Do you want me to go one by one, or?
Yeah, it's the same. As all the other 2003 campaigns.
Go for it, please.
So the First Amendment is number 233126/1. This amendment would require the county to obtain the approval of the State Highway Administration before it places signs relating to the systems on state roads. The Second Amendment is number 993825/1. This would also allow the systems to be placed within 100 feet of a school bus stop. And finally, the Third Amendment is number 753824/1. This would allow political subdivisions to recover their costs for running these systems out of the revenues generated by the systems. That's the same authorization that currently exists for other automated enforcement systems.
Senator Sidner, since he's over in the House testifying, he generally has an amendment that addresses the school zone piece. What's the difference between the 100 feet and his, standard amendment?
So I think the school zones so state law allows local jurisdictions or SHA to establish a school zone within a half a mile radius of a school. And that does allow them to use speed cameras in most cases. And in Prince George's County, it allows them to place a stop sign monitoring system. So the bill and the amendments don't change the ability of SHA or the local authority to designate that school zone in which these could be placed in Prince George's County.
Right, that's the difference. This is relative to where the bus stop is.
Well, yeah, so the current program allows it in school zones, and the bill expands that to school zones and school bus stops.
All right.
And with the amendments within 100 feet of a school bus stop.
All right, well, can we move, do we need to move these separately, or can we move, Sandy, do we need to move these separately, or can we move them all at once?
I mean, that's going to be up to the committee if they want to move all of them.
All right, let's do this. All right, let's start off with the first one. It's within 100 feet of a school bus stop.
Yeah, so this is number 993825, which clarifies that the systems may be placed within 100 feet of a school bus stop. I think this was just some concern that maybe, there isn't a stop sign, like literally at the school bus stop, and this would allow them basically to place the system at the nearest stop sign, assuming it's within 100 feet of the actual school bus stop. So this amendment allows political subdivisions in the county to recover the costs of running the systems from the revenues generated by the systems. This is a similar authorization as exists for most types of automated enforcement currently.
All right, amendment 233126/1 is the appropriation of the money.
No, so this, essentially, I think there was some confusion between the county and the State Highway Administration about who has to place the signs when the systems are on state roads. And this clarifies that the county still places them, but they have to get the approval of SHA before they do that.
Thank you, Mr. Chair. Josh, I'm asking because I don't have it. I'm trying to find it real quick, but does it reference the times of operation for these? Is it all day long or is it just during school hours?
Let me just take a look at the current statute, because if that is, the bill is not touching that. Let me just double check.
Thank you.
What's in there currently. So no, I do not believe they're restricted in terms of the hours that they can operate the systems.
So, Mr. Chair, look, I understand it's about safety at the bus stops. He's saying that the original crafting of the language from the original bill, I guess, is that right, Josh? Does not include during hours of school. This is about school zones. You know, I would like to see us do an amendment that would be during those school hours, and then actually, because of that, in that time frame, I think that's something that even I could support during that time, that we have it dictated that it's during the times and of the design, which is to keep the students safe.
Yeah, just a question that's relative to what you just said. The cameras, you know, Josh, if the cameras that are set up now at schools, they have cameras and schools and all that, do they also work on, Saturdays and Sundays if you're going through a school zone? Or what about after hours?
The speed cameras, they have a restriction on the times that they can be operated.
So
these stop sign cameras do not.
Why not?
It's,
Is it
I don't know.
technologically it can't happen, or?
I don't know if that's the practice of the county, to be clear. But just in the statute, in the speed zone, the speed camera statute, there is an explicit restriction. In this authorization, there's just nothing in the statute about when they can be operated.
If we put that in, what would happen? Because you don't know if they can do that with the technology that they have, or they have technology that if we say do it, they can do it.
I would assume, obviously I'm not going to speak for the county and the contract, but I would assume they can operate it at particular times, yeah.
What do you think?
Correct.
Yeah, on weekends they'll flash, but they're not operating the speed cameras.
Okay, then.
It's during times of school. Yeah.
Okay, I'll go with you on that one if you would do it.
I mean, he seems amenable to it.
I am. I would do that. Yeah.
He'd like.
Thank you. Yeah, I think that's the thing to do. Yeah, I think that's the thing to do.
Oh my gosh, I'm going to actually vote for.
Shanika, you on board with this? I'm gonna buy you a good Christmas present this year.
With a smile. With a smile.
So I have a very serious question. Please, Senator. What happened to Senator Fulton, and will the real one please come out from back?
He came to church, I took him.
It took that long? Thank the Lord for the Holy Spirit.
a car, what type of car would it be?
Chrysler.
A Chrysler.
So the authorization for speed cameras in the school zone is Monday through Friday between 6 a.m. and 8 p.m. Exactly duplicate that?
Yes.
Okay.
All right, so now the bill's before you as amended. Motion's for or favorable with the amendments? Second. Is everyone okay being recorded in the affirmative? Two downs.
Love is down, okay, is down.
Lovin's out of McKesson. I'm sorry. Yeah, sure, absolutely.
Thank you. To explain my vote, obviously, I care very much about the safety of our children and safety at bus stops, but we have heard absolutely no evidence, no information, no data that this is a problem. And so I don't feel like this is a solution. I feel like this is a solution in search of a problem. It sounds lovely. And obviously, I don't want a child to be hurt and then we have to come in afterwards. But I just not hearing any evidence that people are rolling stop signs, that this is a problem. And we have the camera, Prince George's County has the cameras in the school zones on the stop signs. I'm not sure why we need this additional piece. Thank you.
All right. Senate Bill 808 passes with the amendments 9-2. All right, we'll now go on to Senate Bill 758.
Senate Bill 758 establishes requirements for elections of the governing body of a condominium or homeowners association, requires the governing body of a condominium to accommodate unit owner organizing activities related to the governance, prohibits a condominium or homeowners association from charging a unit or lot owner for examining certain financial records, and prohibits the governing body from levying a fee for examination or digitally receiving financial statements. It also authorizes the Office of the Attorney General to adopt regulations to carry out the provisions of the Maryland Condominium Act and Maryland Homeowners Association Act.
Discussion. All right.
758.
Motion for favorable and seconded. Is everyone okay being recorded the affirmative? All right. Senate Bill 758 passes unanimously. All right, we're now going to go on to House Bill 32.
There are a couple of line bills, but I'm talking about 182.
182.
Yeah.
House Bill 32 is the cross-file to a Senate bill that the committee was secondary on earlier this session. The bill requires the Maryland Department of Health to establish a forensic review board at each facility that has persons committed as not criminally responsible. This was the bill that the counsel from Finance Committee came down. It is identical to the Senate bill. Effectively codifies an existing practice in these facilities.
Motion is for.
My notes, not my notes, my computer shows that we unanimously voted the Senate bill.
Okay, move favorable. Second.
Motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. House Bill 32 passes unanimously. Now move on to House Bill 182.
182.
House Bill 182 repeals a statutory provision that sets the maximum amount of $40 for a civil penalty imposed on the driver or owner of a motor vehicle that exceeds the speed limit and is recorded by a speed camera. Instead, the bill establishes an escalating penalty structure with penalties from $50 to $425. There is an amendment in your packet. It's number 573220/1. So the first thing the amendment does is it imports into the bill provisions relating to school zones. So currently, a school zone, as discussed earlier, may be established within a 1/2 mile radius of a school by a local jurisdiction or the State Highway Administration. With the amendment, that would generally be reduced to 1/3 of a mile. However, there is an authorization in the amendment that if the SHA or local authority makes a written determination that it's necessary for the safety of students, they can go back to that original 1/2 mile radius. The other thing the amendment does is it alters just one of the penalties to make it conform to the bill that the committee passed last night on 210. So the escalating penalty structure would be the same as that bill, and the specific change that the amendment is making is if you're exceeding the speed limit by between 12 and 15 miles per hour, the penalty would be $40, equal to the existing penalty.
Thank you, Mr. Chair. Josh, I apologize. You said something about that. What was the provision that they could move it back out to a 1/2 mile?
Yeah, so if the SHA or the local authority makes a written determination that doing so is necessary for the safety of students.
Okay. Is that the amendment that, or is that the discussion that Senator Sidnor was in on?
It was discussed, I think, in a prior voting session on the Senate cross-file about 2 or 3 weeks ago.
Is he going to be coming back? I mean, is he coming back or no?
He is coming back, yeah.
Can we?
It's his amendment. It's not his bill, so I'm comfortable with it, but he just wants it on.
He gets back? I just want him to be able to look at the amendment. That's all. It was his idea. I want to make sure it reads how he wanted.
I don't know when he's coming back, but.
Okay. Committee's pleasure. Okay. I'm good. We have a chance to fix it. You're right. All right.
All right. All right, I'd like to move the amendment. Is everyone okay moving the amendment? Second? All right, now, all right, there are no further amendments, is that right, counsel?
Correct.
All right, now the bill's before you as amended. Motions for a favorable. Seconded. Is everyone, all right, second?
Fulton's down.
Fulton's down.
McKay's down. Fulton, McKay.
Okay.
I'm favorable, but can I get an explanation?
Sure. Senator.
This is Jeff's bill on the graduated fees. And it doesn't apply, for example, it wouldn't apply to my Beltway speed camera bill. That's separate. What does this apply to and what doesn't this apply to?
I'll defer to council, but this applies in the local government section of the speed camera world. So this is school zones and residential areas where the speed limit is below 35 miles per hour. So all the one-off highway bills would not be applicable under this.
Route 210 wouldn't be covered.
No, Route 210 would because we explicitly added it to be consistent with this.
But other than the fact we explicitly, it would not be covered.
That's correct.
Route 210. We had another one for Route 5 that wouldn't be covered.
Yeah, the distinction is basically who runs the camera program. If it's the local jurisdictions, that's in this section of the code. Like work zones, for example, and your bill were broken out into separate sections so that those are run by the SHA.
Okay.
So those would not be covered, but anything that's run by the locals would be covered.
Okay, thank you.
All right, now we're just going to move Senate Bill 118, conform it to the House version, which is the same bill we just passed. Is everyone okay being recorded in the same vote, same posture? All right. Oh, you've worked with me, I'll work with you.
I think so, but I don't wanna be in a position where I'm.
We can, all right.
Even better.
Good response, John. That was the only response.
We're second, oh, no, never mind. Oh, yeah. Why don't you do 76, because we're secondary on that?
The B&T one.
Oh, we're holding it?
Yeah, we're holding. 7-6.
Okay, never mind. We're holding it.
Which one is, oh yeah, I already took that down. Hold it.
Okay.
The exploitation of vulnerable adults. Senate Bill 604.
House Bill 604.
Sorry, House Bill 604.
House Bill 604 is the cross-file to Senate Bill 466, which relates to financial exploitation of vulnerable and senior adults. The House version provides that a person who is a caregiver to or a family member or household member of an individual may not knowingly and willfully obtain the property of the individual with intent to deprive the individual of the individual's property if, one, the individual is a vulnerable adult or an individual who is at least 68 years old, and two, the person knows or reasonably should know these facts. So this is different than the Senate version. It's very similar, though. First off, the Senate version provided not only that a person couldn't knowingly and willfully obtain the property, but they couldn't knowingly and willfully exert unauthorized control over that property. The Senate also struck the provision about being 68 years old. The bill would have just applied, or this provision of the law would have just applied to a victim who's a vulnerable adult.
Can we confirm this? I think, I like what we did better, but, yeah, but. So motion conform, is everyone okay? All right, it's been seconded. Is everyone okay being recorded in the affirmative on that? So we're going to do Senate Bill 520, and that's the same as House Bill 348. And then we're going to go to the rent.
Three, what was it? 348. So House Bill 348 and Senate Bill 520 authorize the State Highway Administration to place and use speed cameras on segments of highways identified as safety corridors. Did we adopt an amendment to this one or no? Do I have to?
April, if you want to come up, help us.
It was probably on House Bill 348 if we did it.
Yes.
Okay.
Changing.
Yeah.
admin.
Bill.
Senator Love.
Thank you, Mr. Chair. April, can you explain what a priority corridor in the administration's pedestrian safety action plan is?
Yes. So the safety corridor means a segment of state highway that is identified by the State Highway Administration as an area of high risk to vulnerable road users in a vulnerable road user safety assessment. And that is prepared in 23 USC 148, or priority corridor in the administration's pedestrian safety action plan.
Right, I was asking, what is a priority corridor in the administration's pedestrian safety action plan? I don't know
It's a
what
segment
those-
it's a segment of state highway that is identified as high risk. It's required by the federal highway and released every 5 years. And in the assessment, the state highway uses 6 years of data to identify high-risk areas on Maryland state and local roadways.
Maybe I'm not being clear. There's 4, 1, and 2. What I'm hearing from you is that 2, the priority corridor, is part of 1.
Yes.
What's the difference? Why is there an or there?
So it's an umbrella. So there's the vulnerable users, and then there's the pedestrian safety plan. So the pedestrian safety plan goes into the vulnerable users, which the safety plan has to have 6 years of data, and the vulnerable road user is 4 years of data.
Thank you.
April, how many miles of state highways fall into these safety corridors at this point? Do you know?
So within the pedestrian safety, we have a total of, let me go to my notes for that. I want to be completely correct. So currently we have 13 PSAP corridors in project development. That's 34 miles out of 17,824 lane miles.
34 miles.
Yeah, that is now to be clear, that is the PSAP corridors. Completely, we have 525 miles, which includes the VRU corridors. That equates to 3% of the total lane miles SHA maintains, which is 17,824 miles across the state.
So 500 and some miles out of 17,000.
Yes, and those also equate to 20% of the fatal crashes across the state.
Thank you, Mr. Chair. April, I just wanted to make sure that everybody knew that yesterday I was given a little different numbers. I want to make sure we're clarifying that, because originally I was told like 3 to 6 miles, and that was not the case, correct?
Correct, it was 3%.
Okay, 3%. And then, because I was speaking about the addition of 80 miles that was moved from Montgomery County yesterday. So were we able to determine on these vulnerable roadway user areas, the VRUs, how many of those fatal or fatalities, fatal crashes, however you want to define them, actually involved a pedestrian who was outside the crosswalk?
That is something that I took to my team to determine the exact numbers for that.
So I just want to make sure that because this piece of legislation deals with the VRUs, and what's the other?
It's the PSAP corridors, which fall under the vulnerable road users.
So it's all about pedestrians or VRUs?
Correct.
So, Mr. Chair, I just want to point out that I spoke with April on this earlier, that the comment was made, I guess, about 20% of those being made, 20% of the fatalities. And I want to know that what we're doing is enforcing the strategy in the right way, because we're waiting to see if 20% of the fatalities, and it would seemingly apparently be vulnerable road users, are the issue. How many of those were struck outside the crosswalks? Because if that's the case, is it the motor vehicles issue, or is it the vulnerable road users that we need to be implementing strategies to keep them more in line with where the safe areas for crossing are, versus penalizing or holding leverage against vehicle operators who have primary usage of the roads? So, and they don't have that yet. But I just want to make sure that that's a question that I think is worth getting an answer to because of them saying that it's 80 or 20% of all the fatalities. That would mean that 100 roughly, the state of Maryland roughly has just under 600 or right around hovering around 600 fatalities a year. That means 120 fatalities are going to be involving these vulnerable user corridors, which a large percentage are going to be thereby deemed pedestrian, whether on a bike or not, which then we've got to look at, is this the strategy that we want to do, or are we looking at enhancing areas that involve crosswalks or safer areas? So I thank you for your time.
I just want to echo, Senator Folden's onto something. I sound like a nerd every time I speak, but I read a bunch of reports on this. So there is this really the intense problem, often in urban areas, often in areas where there's a big economic disparity, so that people that are in those communities are often crossing the roads in very dangerous ways, out of necessity often because they don't have sidewalks or crosswalks or safety features. They also aren't educated well, so often wear dark clothing. I've seen it myself. And then compound the whole darn problem, you have larger and larger vehicles that sit up higher. I'm guilty, I drive an SUV, so that when you impact these pedestrians, you are hitting them in worse areas than you would if the vehicle were lower. So instead of your lower legs, you are often getting them right in their abdomen and chest. So I throw that out because the idea that we should be, perhaps taking more punitive ways to deal with drivers is quite unfair until we grapple with what we do about pedestrians, safety features. These are completely out of the control of Maryland drivers, whether the area is well designed for pedestrians. And so I just have a little concern. I think what we've been mentioning so often in this committee is to take a more holistic, global, data-driven approach to these issues, because this piecemeal, and I worry because once you put a bill in or pass, it's very hard to retract it, but doing things ad hoc, piecemeal, in one jurisdiction but not another, and not really capturing all the data and getting at the core problem. But this is a growing problem across the country, not unique to Maryland. And here we are sort of jumping in to start offering some sort of solution or narrow slice of a solution. And I don't think we have a really good handle on the problem. Thank you.
If I could respond. We completely agree, and that's why this is a data-driven approach. We have a multi-layer approach to this. It's data collection, prioritization, it is consultation and recommendation. So we're collecting data of injuries, crashes, severity, location, roadways at crosswalks, roadways with not crosswalks, shoulders, sidewalks, outside of right-of-ways, curbs, bikeways, school bus zones, and other unknown. VRU crashes by junction type, intersection, non-intersection, intersection-related, commercial driveway, residential driveway, crossover-related, interchange-related, and other driveway, alleyway, railway, grade crossing, and other unknown. Also, VR crashes by fault of party, driver, non-motorist, and unknown. Then the prioritization comes in, and it's areas of further analysis. They're determined by non-fatal, non-injury crashes, density, equity analysis, short trip opportunity areas. Then it's further prioritized by crash data, equity, destinations and connections, highway safety improvement, and activity of density. Then we go on to our stage 3. That's our consultation. In addition to PSAP virtual public meetings, SHA is required to consult with local governments, metropolitan planning organizations, and regional transportation planning organizations that represent high-risk areas. SHA may also consult with institutional advocacy and community groups. Meetings and online survey are available to interested consultants. All input is then received to the consultation process and is provided in the VRU safety assessment and consultation supplement. Then that is when our recommendation goes through. So this is very much data-driven. We agree with you about the piecemeal. We hold this data. We take this very seriously. Safety is our #1 priority. So we just want to make sure that we are clear with speeding kills. And this is going to be, provided to the communities that have high injury and high fatality rates, and that we can offer them this tool to be able to slow people down in their communities.
Thank you, Mr. Chair. April, what were you just reading?
So this is our SHA data-driven approach for identifying safety corridors, and we are very clear on exactly how we are approaching this data-driven. So I wanted to be sure that I had every step along the way of what we do.
Okay. And when you were talking about what data you're going to be collecting?
Absolutely.
So am I correct that that's data that you are going to be collecting, or is it data that you are collecting?
Are.
Okay.
And then this is how our established PSAP corridors are already determined. We went through this entire process, which actually included those public meetings that everyone was welcome to come.
Got it. Thank you. I think, Mr. Chair, last time we talked about this, Senator West brought up a point about shifting entirely how we address speed cameras and whether we should go from, bill by bill by bill to going to something more like this. I know we had a bill with respect to counties as well. And I would just ask that we hold this bill and we have that conversation, that bigger conversation of, is this how we want to move forward with speed camera policy in the state? I think that's a really important conversation that this committee should have.
Thank you, Mr. Chair. So I've really, April, thank you for bringing the data. That's important stuff, so thank you for that. And I think that I almost, man, this might be the third time today, oddly can agree with my good friend from Montgomery County. This is This is a painful day. I don't think I slept right last night or something. But I think that I would like to see it more focused, like the data that they've collected, and be the distribution commensurate with that data approach. I do like that. I like what Ms. King has presented. And then the only real question I have as follow-up, April, is the money's collected, whether it's from these areas that these cameras would be put, does it go back into like the pedestrian safety measures? And I'm asking because I didn't look quickly to find it, or does it go to the does it only go to the TTF?
No, it goes back into the highway safety. So to improve the safety of those corridors.
Okay, into those specific areas. Is that right? It goes back into those specific areas that the enforcement's?
No, I'm sorry. No. They go back into the areas that are found across the state that need improvement.
Improvement?
Based on safety.
On safety improvements?
Yes.
Okay, all right, thank you so much.
And,
Just to respond to Senator Love, were you saying hold the bill and talk about it for a few days and then do something, or were you saying hold it until next year, then we come back and do something statewide?
That is the chair's prerogative as to when we have that.
Oh, yeah, I didn't want to hold it. I can just hold on. Okay.
Thank you, and I didn't have the bill in front of me, so I didn't want to make this comment or ask this question, but to the person who's speaking, I'm sorry, hello.
Hello.
Your name is what?
April.
April. Hi, April. I think you tried to reach out to my office. So I really appreciate it.
No problem.
I think where I'm struggling is I love all the data, but I don't think I'm comfortable until that data is captured, because this bill has a component for, putting speed cameras. And and I know you're aware of this, we have all kinds of speed camera bills coming in year after year in in a way that may be good for a community, but not statewide, and in sort of an ad hoc way. So I don't know. And so what I'm really struggling with is I like getting all the data, but jumping to a camera and penalties until we can see at the heart of the accidents how many of, I mean, speed can always harm somebody, of course, and that more speed is worse. But I think a lot of these accidents, I don't even know if speed is the problem as much as the pedestrians are vulnerable and in areas that are not well intended for them. And in fact, many of them are crossing areas that are not intended for pedestrians, but because of other factors in the community, they choose to use these roads, right? So not bringing that aspect into it and addressing the fact that many, because this is happening in my county, people are crossing roads that they are not intended to cross at all, and accidents are happening. And so I feel like before we jump into penalties, we ought to get more of that data that you are so willing and able to get for us. Does that make sense?
It makes sense, and that's perfect because when I emailed you today, I actually included our report that we have already captured that data and that it is been published and it is a public piece of information. So I agree with you that it should be published, and that is why it is important for us to move forward on this because we have captured that data.
How much data is it, ma'am?
It's 6 years worth of data.
Yeah, so, I mean, in other words, is it hundreds of pages, thousands of pages, or?
How long's the report?
Yeah.
Ooh, that I would have to look at to see exactly the number of pages of the report, but it is very in-depth.
Then is there any, is there a condensed version that is accessible for legislators yet available?
This is a public report, and it is based on our website, and we do have a link that I have sent to your email address that you could access at any time.
Did that just come today?
Yes, I sent that today with all the additional information.
So the struggle is where we are in the session, and I don't know if I have the time to read 6 years.
No, I completely understand.
All right, thank you, Mr. Chairman.
That's fine. Just one thing I just want to mention is that our program does not affect the local programs. The local programs would still be able to act and operate along the same lines as our program. But I understand Senator Love's concern, so I just wanted to make that very clear that we would not be overrunning a certain corridor or not being able to work with the locals. We would more than happy to work with everyone.
Just say, Senator West, go ahead.
And that I think the concern that Senator Love and I both have, and I suspect others do as well, is if we're going to lateral to other organizations and give them carte blanche to put speed cameras up, we need to circumscribe that carte blanche with certain parameters that would delimit what they can do. So if we no longer are going to approve each one and we're going to let other people approve them, we need to have some sort of controls over what they have the right to approve. So it would apply not only to the state in this case, but if we, for example, give the right to Montgomery County, we would want to have the same sort of limitations on what Montgomery County could do. I sort of think that's the way to go long term, rather than each of these bills come to us all the time, every single year. But that's a conversation for us to have.
Limitations and still be having the same citation amount and following the same miles per hour that we have been doing. And we have to follow these strict limitations from the federal guidelines. We wouldn't be able to just go out there throwing speed cameras around wherever we like on our highways.
Excellent. Thank you. Well, thank you very much. This has been very, very helpful. So thank you for your willingness to step up. This is great.
And if you have any questions, you can email me.
Yeah, we'll be in touch. We'll be in touch.
Thank you.
Thanks a lot. All right. So now we're going to move on, looks like we're going to move on to House Bill 767. That's John.
House Bill 767 is the cross-file of Senate Bill 442, which is still in the committee's possession. The bill establishes additional requirements once a court has issued a warrant of restitution and a failure to pay rent, breach of lease, or tenant holding over action, including requirements related to notice and the storage of tenant's property. Specifically, if the district court issues a warrant of restitution, the landlord must give at least 14 days written notice to the tenant before the date of execution set by the sheriff, and a tenant must be given 10 days after the execution of a warrant of restitution to recover the personal property from the premises or another reasonably secure location chosen by the landlord. The bill also establishes civil remedies for a tenant if a landlord violates the bill. The House made a couple of changes. One, in addition to the requirements to send notice under the bill by first-class mail or posting it on the front door of the property, the landlord must now send it electronically if the landlord has the tenant's email or cell phone number. They made some technical changes regarding the content of the notice, and then they made some further clarifications that any removal of the possessions, if it includes like a pet or an animal, has to be done with existing protections regarding animals.
McKay. And Senator McKay. So, thank you, Mr. Chair. So we have an eviction process that's already in place, 30 days. After 30 days, then they can apply to evict the person. So they have to wait a whole month before they can apply for eviction. Is that correct?
So, yeah.
So then, this bill then, before they can apply, then they have to go, so they're not eligible to apply until 30 days. Then they have to give a 14-day notice that they're going to apply for the eviction. So pushing this out to like 44 days at this point before they can serve the person with the eviction paperwork.
Well, so like, I think, so that's one of the important things. So as a baseline, just understand the timelines. And so, John, I'm gonna rely on you this. Like, as we learned from a very spirited floor fight, which has become infamous now, you got breach of lease, failure to pay rent, and then tenant holding over, right? So so you're right. There's a period of time where you didn't pay the rent, so that's 30 days, okay? And then, let's say, John, what is the notice before you file an eviction notice? You have to do what under Maryland law? How many days do you have?
For a breach of lease, before you can file, you have to give 30 days written notice, or if it's a serious breach of lease, they can do it in 14 days. If it's failure to pay rent, the notice is 10 days.
Okay, let's just stick with, so, okay, so, all right, so for breach of lease, you have to give 30 days notice?
So
generally.
Okay, so let's just, under your scenario, it's
30 days.
Rent. So your rent, you're 30 days due, okay, but then you have to give, for failure to pay rent, let's just go under that method, okay? Because that's what your scenario is. Then it's a 10-day notice? Okay. And then under the bill as drafted, you have to have 14 days? So wait, let me ask you this. First, let's take a step back. 10-day notice, and then you go to court, and this is jurisdictionally probably different, but you go to court, you find a court date, and maybe we have attorneys here that do this, so if they could come up and help us, walk us through that. I mean, if you guys, whoever's willing to join. You find a court date, then you get a judgment, okay? Then you have to wait 4 days after that judgment for appeals, or what?
For a failure to pay rent, it is 4 days for that appeal window.
All right, okay, so all right. So you get 30 days of rent not being paid, and you get 10-day notification, then you find a court date, then you have 4 days after that court date disposition for appeals. Okay.
So we're at 44.
Then we're adding, the bill adds what?
After that, there has to be at least a 14-day notice prior to that, whatever the sheriff sets as the eviction date. And then.
So we're at 58 at a minimum.
And then 10 days after that eviction date is when is the reclamation period where they have to hold the.
I'm trying to understand the timeline.
Possessions.
So then 58 days is where we're at, and then and before they can be removed, and then they have to hold the property for 10 days beyond that,
after the
which gives us 68 days.
Okay, well, hold on. So for failure to pay rent, when do you file? So failure to pay rent, we're going to operate under that method right now. when can a landlord file for failure to pay rent? When can you file?
Sure. So at the time where the tenant has failed to pay the rent, the landlord gives a 10-day notice to the tenant asking them to cure within those 10 days. If they do not, then they file a failure to pay rent case. And that is up to the court to set the trial time. So that depends on the jurisdiction. So
It's on resources, dockets.
Right, that's
all that.
But I
resources.
want to be clear that we're all on the same page here. So it's 30 days, then you have 10 days to file.
10 days. So it starts with 10 days.
But it's 10 days after they haven't paid for 30 days.
No. Well, it's 10 days after they haven't paid. So they haven't paid.
You're both right. So it's 30 days after you paid your last rent, but the rent's not due until it's due.
Okay.
So it's from that date.
So 10 days.
Right.
Then
10 days, then it's set by the court, and each jurisdiction is different, right?
Could be how long?
So I practice in Baltimore City. What we see is about 10 to 14 days.
So
that is typically what we see from filing the trial. That's what we see.
All right.
Other jurisdictions longer. Anne Arundel County does 4 days, right?
All right.
And after that, once judgment is entered, then what happens is the landlord must wait for the appeal period to last. Appeal period is 4 days.
4 days.
And then another 3 days for the warrant to be given out. So it would be a total of 7 days. So the landlord wouldn't be able to get a warrant for at least 7 days from the entry of the judgment. They take that warrant to the sheriff's office. Sheriff's office then gives them an eviction date, and that eviction date is based on the time where the sheriff can make that work. Timeline in Baltimore City is generally 3 to 4 weeks.
3 to 4 weeks.
So that is from the warrant been given to the sheriff to the actual scheduling of eviction.
So we're at basically 31 days, give or take. Then you got 3 to 4 weeks before the actual.
So I would say 10 days.
10 days.
Plus maybe trial. So let's say 14 days, you have 24 days.
So that's 24.
24 days. And then if we add 7 days.
7 days, that's 31.
31 days.
And then 3 to 4 weeks before the sheriff's office gets out there to evict. So basically you're 2 months.
Correct, yeah. I mean, so for the purposes of Baltimore City, I think that's about right, Senator. Okay. I would say for small jurisdictions, that's possible to be shorter.
Sure.
Based on the capacity, Anne Arundel County much shorter.
Yeah.
Because of the
Completely.
Right.
Completely understood.
So the 14 days, that's the notice period. And the reason that the 14-day notice period is important for these type of situations. So in Baltimore City, we have a 14-day notice period, and that doesn't extend the eviction timeline because the eviction happens within 3 to 4 weeks from the issuance of the warrant. So this 14-day notice has no bearing on Baltimore City, has no bearing on Prince George's County, Baltimore County.
So for the purposes of this and you describing the timelines, is it safe to say that we could be roughly 52 to 60 days by the timeline you've given before the person would be evicted? And then at 52 to 60 days, there would be a 10-day additional cooling or reclamation period for the furniture. So we could be at 60 to 70 days roughly.
That is correct. So to be clear, the eviction process takes place, and the eviction is to take the property back from the tenant and give it into the landlord's possession, which means that for the purposes of the eviction process, the process would not be changed substantially by this period. But now it's true that the landlord would need to hold that property, but it's not descriptive based on what this bill says. So they can take that property, they can put it in a third location.
Okay,
they can
but
have
that's at whose cost?
That would be at the landlord's cost, yes.
Correct. So my point is sheriff shows up, does the eviction. We're around 52 to 60 days. And then the property, technically, by the way this was written, would stay on site unless the owner of the property chooses to pay to have it moved off-site, and it would stay there for 10 days that they couldn't do anything with it. They couldn't rent it, and they couldn't rent the space, and they couldn't do anything with that furniture, like dispose of it. Because normally on an eviction, when the eviction occurs, as it happens now, what can happen to the furniture that's in the residence?
So as of right now, when there's an eviction that happens, they take the furniture and they just throw it out to the street.
It's on the curb.
And it's considered abandoned at that point.
It's abandoned property.
Yeah, and I think that for the purposes of this reclamation period, it kind of speaks to what the Fourth Circuit Court of Appeals stated in Todman, saying that provisions where there is an abandonment statute, where there's an eviction happen and the state or the jurisdiction has said this property is considered abandoned upon eviction, that is a violation of due process. So that spoke specifically to Baltimore City's eviction procedure. And in Baltimore City, what they do is when the eviction is done, they lock the property and they say, well, the property's abandoned.
So I just want to be clear, on the thousands, probably tens of thousands of evictions that have happened through all the years, or more, we have a judge now that has said that that's no longer abandoned property. That's, so on one opinion.
Yes. Yeah, I mean, so I think the reason why it is like that is because all the other Fourth Circuit jurisdictions have this reclamation period. Okay. And Maryland is way out of line on this. And that is kind of why this opinion has.
Reclamation time. It just says that, look, like what happened under this scenario was clearly not under the law. There was not enough time.
Yeah, it's not prescriptive.
There was no time. I mean,
yeah, it's not prescriptive. Yeah, there's no time. It's not prescriptive on how much time there is. It's kind of doing a counterbalance under the Matthews adjustment, saying what is a equitable time for this person to, one, have the due process and to be able to even do that, to be able to reclaim their property. So the time specifically.
There's time during this whole process to reclaim your property.
There is, however.
So there's 2 months.
However, so I guess that's on the first end. So as of right now, statewide, Maryland does not have any notice provisions. So Prince George's County, they are not given a notice when their eviction happens. They're given a notice saying your eviction is going to happen within a week. What day on the week? That's your guess. If you're not out by whatever time that's in. And that's kind of the issue with the Todmans a little bit. And that sets for many other jurisdictions. Okay. And to that point, I think, regardless of if there's notice, under the due process rights, there needs to be some type of opportunity to be heard about your personal property. So there is no notice prior to the court date, prior to the actual eviction date, that your personal property is at risk of being lost. And so that is kind of why due process should apply potentially to the personal property, and which is why other states have afforded this type of reclamation period.
Maybe it works like that in Baltimore, but in Prince George's County, people really don't know when they're going to be evicted. I listened to people talk about that, and then I had one of my staff pastors go out and pull out, just get some information from as many of our churches as he could. Of those who were evicted, nobody knew which date they were going to be evicted. That's the problem. Maybe that's only in our county. Maybe it's because they don't have the manpower to do it. Then in most states, they will do, I think, we're at 10 days, but in most states, it's 7 days. And so I'd be willing to come down to 7 days, but what I won't do is continue to let the possessions of people be set out. It's barbaric to me, just set out on rain, set out, and half of it's broken because the people who are contracted to do the moving, they don't care, and it's broken, people steal it. I just think there's a better way and a more civil way, humane way, that we can deal with evictions. And so I know we're saying 10 days, but if there's an amendment for 7 days, I can go with that. But when we say notify, first of all, I don't think we have the manpower to do that, the man and woman power to do that. We just don't. And notifications, what does, it's not a notification saying, well, tomorrow you're going to be evicted. And sometimes, they don't know at all, even a roundabout time frame. And it takes time to deal with that, especially if you're poor. It takes time to pull that together when you have nowhere to go. And so I think that 7 to 10 days is a reasonable time for someone to protect their property, all that they have. And it's bad enough to be evicted, but then to walk away with nothing and everything's broken. For me, that's where I am.
There's got to be at least that's a statewide standard. You have to have at least a 10-day notice before the filing of the eviction. I mean, that's, so everyone knows at least 10 days ahead of time before I'm going to file on you. I'm going to file 10 days.
Where is that?
That's in the law now. That's the law. We passed that 2 years ago, 3 years ago. You have to get a 10-day notice before someone files for eviction. But yeah, I'm sorry. I know. I'm just saying that's what the law is right now. Whether it's happening in practice, I'm just saying it's the law right now. Senator West.
So I'm looking at the Todman decision, and here's what Judge Wilkinson says. He says, but the instructions in the warrant of restitution were misleading and confusing at best. The instructions were not clear as to which types of evictions they applied to, and information relevant to the potential for abandonment was buried among so many other items that it almost assured a tenant would overlook or fail to notice it. I think that was the problem. So we can solve that problem by requiring that the 14-day notice include language which we prescribe in bold capital letters, which informs the tenant in no uncertain terms that if the tenant does not remove the property before the eviction, it will be considered abandoned. And I think that would suffice under due process. That's what we're not doing now. We don't need to give an additional 10-day period after the eviction to do it. We need to give proper notice prior to the eviction that the tenant needs to remove the property. Am I correct in that?
So I would push back a little bit on that. So the notice provision is specifically dealing with pre-adjudication, right? So when we're talking about the notice provision for the eviction,
no, this is
on the 14-day
notice as part of
notice.
the warrant of restitution.
Right.
This is after the decision's been made to go forward with eviction.
Right.
This is the next notice you get.
Right. And so if we're talking about due process, what is the understanding of when the eviction is happening? Is it when the notice is given, before they can have any type of time to be? I understand, but if the purpose of the Todman decision, or the purpose of the bill, is to allow for human error to be adjusted if that's the problem, right? So if someone is evicted and they don't know that their eviction was coming, if there's some issue, such as the Todmans, there is some time between the loss of the eviction and the loss of the property where they can either get the property back, where they can go back to the court, where the sheriff can make sure that this opportunity to be heard is found.
Well, no, wait a minute. There was an opportunity to be heard at the time of the eviction hearing, and the tenant lost the hearing, and therefore the warrant of restitution was issued. So the tenant has had an opportunity to be heard. All we're talking about here now, I think, is properly informing the tenant that if the tenant fails to remove his property by a date certain, that the property will be deemed abandoned and the landlord can do with it what he wants. Why would that be considered to be a violation of the tenant's due process?
Because at the time of the hearing, we're talking about a breach of the lease, a breach of not paying the rent, which is, generally speaking, if you're someone who's not a legal professor or a lawyer, you think this is for the real property, not my belongings.
Well, let me take it back a step then. Suppose we provide as a matter of law that at the time of the eviction hearing, if the tenant is present at the hearing, and frequently they're not, at the time of the hearing, the judge is required to inform the tenant that if the tenant doesn't remove the property prior to the sheriff arriving to evict the tenant, the property will be deemed abandoned. And then cover our tracks by saying in the 14-day notice, a provision which we will design in bold capital letters has to be provided to the tenant to further notify the tenant that the property needs to be removed prior to the time of the eviction. I don't understand why due process requires that after the eviction has taken place, yet another notice needs to go to the tenant that the tenant needs to move his property away.
So the only notice that would be given that we're adding is a notice that we've already done in Baltimore City. And this is just a notice saying that you have this eviction date coming, you need to move out or redeem the property or whatever.
No, the notice would say, you know, you've lost your eviction case. If you don't remove your property prior to the time the sheriff arrives to evict you, the property will be deemed abandoned. That seems to me should be sufficient notice of the tenant's rights to remove the property by a date certain, right?
Well, I think the notice and the time to be heard is the issue, right? So they'd be on notice, but they wouldn't have had that due process of being heard because everything up before that was about the real property and not the actual personal properties.
So you keep talking about a right to be heard. Are you claiming that after the eviction occurs, the sheriff arrives, and the property is left in the apartment, that the tenant has another right to be heard before a judge as to whether or not the tenant has a right to that property? Is that your claim?
I believe that there needs to be some mechanisms out there for that. So
I just disagree with that, and I don't think you can read the Fourth Circuit as holding that either.
Okay.
So first of all, the 10-day notice that we passed, that along with the lead inspection, and if it was built before 1978, and a inspection by the municipality, has to be in the file for the administrative court judge to actually even schedule a court date. So to say that the person doesn't know that they didn't have a 10-day notice is absolutely false. All that has to be before you can actually get a date. And if it's not happening in Prince George's County, okay, well then you need to talk to Judge Morrissey about it then, because then his administrative court judges are not doing their job. I know firsthand how this works and how this doesn't work. There again, if in Prince George's County they're violating the law, I'd be very, very surprised that they're doing that. Second of all, it was in the testimony when we heard this bill that the reason they came up with 14 days was it takes about the sheriff about 14 days because of the volume to actually get to that. Well, that's an arbitrary number. In Allegheny County, you can get it within 3 to 5 days. So why would we pass a bill that's going to make it even harder for a landlord to get their money back? Not their money back, but get their possession back. I really don't understand how a tenant who didn't pay their rent, who got a 10-day notice, who then had a court date, who then had the ability to appeal that court date, didn't know that their stuff was going to be evicted. And if that is true, then all the time and energy that this body, those who have advocates for it, and those who are proponents, ought to actually donate all their money and educate the tenants and say, here's how we're going to get this. The real question that I don't believe we attacked is that we have homeless wraparound services to help to make sure people are not homeless. Do you know that you can't get homeless wraparound services until actually the court date has been found and an eviction date has actually been set? So we're putting money into to help people that we can't even give them the money first before we actually have had an eviction date. And then once that person has that eviction date, they then are interviewed and they get the ability to get that money. Then they call the landlord and say, are you willing to work with the tenant? Not how much money are you willing to give, but how much are you willing to work? In my case, absolutely I'm willing to work with. I am still sitting on waiting for a check 10 days later afterwards. I'm willing to work with, gave the 10-day notice. To be perfectly honest, I was the stupid one because I let him go 3 months with not paying rent. He paid $20 here, $15 here, $20, because I'm trying to work with him. The system is broke. It's not the General Assembly that needs to fix it. It needs to be the advocates that actually help these people to make sure that they don't become homeless. I apologize But I get really, really frustrated day in and day out, or year in and year out. We come to this body and we bang on the landlords like they are the scum of the earth. Now, don't get me wrong, we've got bad landlords. But let's work on fixing that instead of throwing out the whole baby in the bathwater, because we're not making it easier to rent in Maryland. Why would you want to be a landlord in Maryland? Makes no sense. Why, either it be just cause or it be rent control, all these different things, I'm telling you, you're making it more expensive for people to find affordable housing. And you're chasing out good people who want to help people because you're making sure that it's not worth it. So I apologize, sir.
Understood. Thank you.
Thank you, Mr. Chair. You know, been going back and forth with this bill, and every time I think about it, I try to find the balance between what's right and what's wrong. And I think the most important piece, you know, I got an opportunity to look at the eviction notice that was given to one of my constituents in Prince George's County, and there was no time, there was no date, there was nothing put on the eviction notice. So how do we get around this problem and this major issue? And I think Senator West, he brought up some very good points in terms of the language that needs to be put onto the eviction notice. But one of the things that he didn't mention that I think is very clear, and I've expressed it to the advocates as well, is that we need to have the time and the date. Now, obviously, everyone knows if you haven't paid your rent, you're going to be evicted from the property, especially if you've gone through the court process. You got the 10-day notice, then you got the 4 days to appeal, and the sheriff's warrant is issued. You know you're going to be evicted from the property. But I think the most important piece, not giving additional time, I don't necessarily agree with the additional time. I think the person, as Senator Folden had mentioned, we're already 60 days in. And you add an additional day, we're 70 days in, where a small landlord is now being put in a position where it's going to take them even more time to actually retrofit the apartment to get it back on the market. And we're hurting people that's living on fixed incomes. So how do we fix this issue and help those who are being evicted and running the problems, but also take care of the small person, the small landlord who literally is living paycheck to paycheck and can't make that mortgage payment on the property if they have a tenant who's not paying. So we have to take all of these things into consideration. And I think the most important piece is putting a time and a date. I gave some of the stories to some of the advocates about, as a child, going back to the apartment complex, you know, that I grew up in, and us getting off of the bus and seeing some of my friends seeing their bedroom sets outside at the bus stop. We're talking about stop signs earlier at bus stops, their bedroom sets and all of their clothes and all of these things at the bus stops, and the heartbreak they had, you know, seeing this. And this isn't because of the child's fault. It's obviously an adult who didn't do what they were supposed to do to pay the rent. And so I think the most important piece, so we can cover all of our tracks, is taking into consideration what Senator West brought forward with is articulating on the documentation that by this particular time and date, if you have not removed your property from the apartment, then you will, or the house, because this is also houses as well, if you haven't moved it from the location, then it will be deemed abandoned and removed. And so I think it's simple. I think we put too much context and we make it all legalese. These are everyday regular people. We got all of this legal minutia that goes into what we're saying. We just need to make it very common and simple for the everyday person to be able to understand. At this date and time, if you don't have your property out of the location, it will be abandoned. As simple as that. And like I said, I don't think you need an additional 10 days. I know from one of my constituents who ran into this problem, her situation was completely messed up, right? But if this provision was in place prior to, I don't think we would have ran into this particular problem. So putting the date in, I don't know how you feel about the date and the time being actual due process. But I think that's something that we really, I'm very comfortable with putting a date and time in on making that standard across the state. And I don't know if anybody else has issues with that, but a date and time on every eviction notice that at least gives people the opportunity to know when their property should be out of the facility.
As a compromise with that. So when you call the sheriff's department, they're going to give you the day that they know that they can come. They can probably tell you if it's going to be in the morning or it's going to be in the afternoon. I would be fine with that then has to be articulated to the tenant right away in the same fashion that our 10-day notice is. It's a form that gets filled out that says, I've contacted the sheriff, they're going to be here on such. It may be 14 days in Baltimore City because of the backlog. It may be 3 days or 4 days in Allegheny County. But to speak what you're saying, Senator, is they would at least know morning or afternoon on a particular time that the sheriff is coming. That wouldn't be that burdensome on the landlord to articulate that in a form that gets then put on the door saying the sheriff will be here on Monday in the AM.
All right, well, look, we have some additional work to do this evening. This is a very, very good discussion, so I want to thank the members for their thoughtful commentary. I wonder if you all would, so we're back on the floor at 10 o'clock tomorrow, so, and it looks like we'll have not a short, but not an extremely long session, but I wonder if you all are available during the floor session. We could pull some people off and engage in more conversation. If you all around tomorrow during the floor session, we can do that in the Senate lounge. Whoever wants to partake in that can be in there. All right, we're going to hold that just based on the level of discussion that we had, and we'll conclude our hearings and our voting session there. And we'll see you tomorrow at 10 a.m. Thank you all for a very thoughtful session.